Next page. Chapter 11 Insider Trading. 11.1 Introduction to Insider Trading. Definition: trading shares or securities using non-public, privileged information for personal profit or loss avoidance occurs at the expense of other investors who lack access to such information. Legal framework. Financial Markets Act, FMA, prevents abuse of insider trading to ensure transparency in stock markets. Financial Sector Conduct Authority, FSCA, supervises compliance with Chapter 10 of the FMA on market abuse. Objective of regulation: enhance efficiency, competitiveness, fairness, and transparency of financial markets. Examples of insider trading. 1. Managing Director, MD case. MD of a mining company learns that newly discovered mineral deposits are of poor quality. Knowing this information will cause share prices to drop, he sells 50% of his shares before public disclosure, avoiding losses. Illegal use of insider information. 2. Case law, SV Western Areas Limited. Accused bought shares in Randfontein Estates Limited with knowledge of an upcoming acquisition offer by Western Areas Limited. They secured a guaranteed profit by purchasing shares before the announcement. Verdict: found guilty of insider trading. Defenses under the repealed Securities Services Act, SSA, were unavailable. Evolution of insider trading laws. Companies Act, 1973, S440, Insider Trading Act, 1998, Securities Services Act, SSA, 2004, Financial Markets Act, FMA, 2012, FMA, effective 3 June 2012. Identifies criminal offenses and defenses for insider trading. Allows civil remedies, compensation for affected parties. Case law, Zietsman v. Directorate of Market Abuse. Addressed whether inside information was specific or precise. Facts: insiders bought shares in a company after learning of a potential, a $99 million loan from the Industrial Development Corporation, IDC, before it was public. Court's holding: information need not be in final form to be specific. If likely to materially affect share price, it qualifies as inside information. Defendants fined are $1 million. 11.2 Insider Trading and the Financial Markets Act, FMA, Legal Provisions. Chapter 10, SS 77-88, deals with insider trading and market abuse. Regulators: Directorate of Market Abuse, DMA, FSCA, Financial Sector Conduct Authority. 11.2.1 Definition of an insider and inside information. Insider, S77 FMA. A person who possesses inside information through employment, directorship, or any privileged position. Inside information, S77 FMA. Specific or precise information not made public, obtained as an insider, and likely to materially affect share prices. 11.2.2 Regulation of insider trading. Key offenses, S78 FMA. An insider who trades securities while knowing they have inside information commits an offense. Applies to direct or indirect trading, including through an agent. 11.2.3 Insider trading offenses. 1. Dealing in securities while in possession of inside information, S78 FMA. 2. Encouraging or inducing others to trade based on inside information. 3. Disclosing inside information to another party, unless permitted by law. 11.2.4 Defenses to insider trading. 11.2.4.1 Defenses to dealing in securities for own account. Valid defenses include: trade was not influenced by inside information, pre-existing trading plan, automatic trades planned before acquiring inside information. 11.2.4 Defenses to dealing in securities for another. Transactions conducted in good faith, and without using inside information. 11.2.4.3 Defenses to dealing for an insider. acting on specific instructions from a client without knowing they have inside information. 11.2.4.4 Defense to disclosing inside information. Disclosure required by law or made in the course of employment without intent to facilitate insider trading. 11.3 Insider Trading and the Companies Act, 2008. Companies Act, S76, 78, 162, 218. Directors and prescribed officers prohibited from using inside information for personal gain. Shareholders may claim damages if harmed by insider trading. 11.4 Insider Trading and King IV. King IV Corporate Governance Code requires transparency in securities trading by executives and directors, promotes ethics and fair market practices. 11.5 Johannesburg Stock Exchange, JSE, and insider trading. JSE listings requirements. Directors and executives must disclose share trades. Trading windows restrict trading during sensitive periods, for example, before earnings announcements. Sanctions for insider trading include fines and delisting risks. Market abuse, Chapter 10 FMA, Chapter 10 Structure. S77 Definitions. S78 Insider Trading Offense. S80 to 81 Prohibited Trading Practices, Misleading Statements. S82 Liability for Insider Trading. S83 to 85 Enforcement Procedures, FSCA and Directorate of Market Abuse. S88 Confidentiality Provisions. These notes provide a concise yet comprehensive breakdown of insider trading law in South Africa, emphasizing key cases, legislation, and regulatory frameworks under the FMA, Companies Act, King IV, and JSE requirements. Let me know if you need further case analysis or legislative interpretation. Next. Page 11, 2 on the definition of an insider, and of inside information. Insider, a person with inside information. This includes directors, employees, or shareholders of issuers, whose securities are listed on a regulated market, individuals with access to such information due to employment, office, or profession, persons who know the source of information comes from someone mentioned above. Inside information, specific, non-public information that, if made public, would significantly affect the price or value of a listed security, includes information learned through an insider position. Zietsman case, the court emphasized that it's the potential of information to affect prices, not its actual effect, that determines whether it is inside information. Core concept, the fiduciary relationship between the insider and the company. Example of insiders: legal advisors, accountants, and journalists with access to confidential company information. Regulation of insider trading. Companies are required to disclose material price-sensitive information, such as through cautionary announcements, for example, Nedbank's 2010 cautionary announcement. 11.2 The regulation of insider trading. FSCA's role supervises compliance with Chapter 10 of the FMA. FMA powers grants broad powers to FSCA to oversee insider trading activities. 11.2.3 The insider trading offenses. Under Section 78 of the FMA, there are 5 insider trading offenses. 1. Dealing for oneself, engaging in securities trading while possessing inside information. 2. Dealing on behalf of another, trading securities on behalf of someone else while in possession of inside information. 3. Dealing for an insider, dealing in securities for an insider who possesses inside information. 4. Disclosing inside information, sharing inside information with others. 5. Encouraging/discouraging others, motivating another person to deal in securities using inside information. Example: the FSCA investigated trading in Steinhoff International shares, but found no evidence of insider trading despite a significant drop in share price due to the accounting scandal. 11. 2.4 Defenses to insider trading. General defense requirement: an insider can avoid liability if they prove, on a balance of probabilities, that a defense applies. 11. 2.4.1 Dealing for own account while having inside information. Defenses: the insider became aware of the information only after instructing an authorized user, and the instruction wasn't altered after becoming an insider. The transaction involved all parties possessing the same inside information, and was not intended to benefit from price movement caused by the inside information. 11. 2.4. Dealing for another while having inside information. Defenses: the person was an authorized user acting on specific instructions, unaware the client was an insider. The person became an insider only after giving the instruction, which wasn't altered after becoming an insider. The transaction involved all parties possessing the same inside information, with no intent to profit from price changes. 11. 2.4.3 Dealing for an insider. Defenses: same as for dealing for oneself or another person. 11. 2.4.4 Disclosing inside information. Defense: disclosing the information was necessary for performing the functions of one's role, with the disclosure made to the relevant person, and accompanied by a notice that the information was inside information. 11.3 Insider Trading and the Companies Act, 2008. Indirect regulation: the Companies Act, 2008 does not directly address insider trading but touches on fiduciary duties of directors. Directors must not use confidential company information for personal gain, or to harm the company. Directors must disclose any material information to the board. Section 76(2) of the Companies Act codifies these fiduciary duties. Example of fiduciary duty: an auditor accessing inside information cannot use it for personal gain, and must report it to the board. Director disqualification: Section 69 disqualifies individuals convicted of offenses like insider trading from acting as directors. These sections highlight the core elements of insider trading regulation, the legal responsibilities of insiders, and the various defenses available to individuals accused of insider trading under South African law. Next page. 11.4 Insider Trading and King IV. King IV Code on Corporate Governance does not directly address insider trading, focuses on ethical leadership, transparency, and good governance practices. Key principles: promotes trust, good reputation, and legitimacy. Advocates for a stakeholder-inclusive approach, balancing interests of the company and its stakeholders. Directors' personal interests should not surpass the interests of the company or stakeholders. Emphasizes fair, responsible, and transparent remuneration, avoiding secret profits or undisclosed benefits to insiders. Example of insider trading. Scenario: Mr. Jones, an IT consultant, accesses confidential merger information while fixing a virus on a company director's computer. He buys shares based on the non-public information. Outcome: Mr. Jones is considered an insider with inside information and engages in insider trading. 11.5 The Johannesburg Stock Exchange, JSE, and insider trading. JSE listing requirements focus on the dissemination of material price-sensitive information, for example, mergers, acquisitions, to curb insider trading. Ensure equal access to information for all stakeholders, minimizing insiders' advantages. Key provisions. 1. General obligation of disclosure. Issuers must disclose material developments not known publicly that could significantly impact share prices, without delay. Exceptions: information may be kept confidential temporarily. 2. Trading statements. Triggering conditions: issuers must publish trading statements if financial results will deviate by 20% or more from the previous period or forecast. Requirements. Specific guidance include period, comparative numbers, and percentage differences. If a deviation in results occurs after a trading statement, issuers must release revised guidance. Limits: the use of terms like significant, material, or substantial in trading statements is restricted to prevent ambiguity and ensure compliance. Next page. Chapter 12. 12.1 Options for financially distressed companies, a new approach. Companies may fail due to various factors, for example, poor management, market conditions, etc., which is normal in a market economy. While company failure is inevitable, it can have significant economic and social consequences, including job losses and community impact. Since the late 1990s, there's been a shift towards rescuing financially distressed companies rather than liquidating them. Corporate rescue or business rescue refers to efforts aimed at restoring distressed companies, though it doesn't guarantee success in saving the company. Business rescue may involve restructuring, selling the business as a going concern, or providing a better outcome for creditors than liquidation. South Africa introduced judicial management in 1926 as an early attempt to rescue companies, and now the Companies Act, 2008 provides formal business rescue procedures. Both business rescue and compromise with creditors are options for distressed companies. Part A, Business Rescue Proceedings. 12.2 The concept of business rescue. Objective: business rescue seeks to rehabilitate financially distressed companies, maximizing the possibility of continuing the company on a solvent basis or ensuring a better return for creditors than liquidation. Business rescue definition, Section 128(1)(b), Companies Act, 2008. Temporary supervision of the company's affairs, business, and property. Temporary moratorium on claims against the company or its property. Development and implementation of a rescue plan, if approved, which involves restructuring the company's affairs, liabilities, and equity. Goal: to save the company, if possible, or provide a better return to creditors than if the company is liquidated immediately. Oakdean Square Properties v. Farm Bothfontein case clarified that both goals of business rescue, restoring solvency, or providing better returns than liquidation, are equally valid for initiating business rescue. Difference from judicial management. Judicial management only focused on rescuing the company to pay debts. Business rescue, by contrast, provides more flexibility and is not as exceptional. The test for granting business rescue orders is less strict than judicial management. Financial distress, Section 128(1)(f). Commercial insolvency, company unable to pay debts as they fall due within the next 6 months. Factual insolvency, company likely to be insolvent in the next 6 months, liabilities exceeding assets. Affected persons, Section 128(1)(a), shareholders, pre-commencement creditors, trade unions, and employees, including those not represented by unions. Note: only shareholders, not securities holders like debenture holders, are treated as affected persons in business rescue. 12.3 Resolution by Board of Directors to begin business rescue. 12.3.1 Procedure to commence business rescue. Business rescue resolution by board. The Board of Directors can initiate business rescue proceedings by adopting a resolution. Notification: affected parties, shareholders, creditors, trade unions, etc., must be notified, and a business rescue practitioner is appointed. Consequences of non-compliance: failure to follow prescribed procedures can invalidate the resolution. 12.3 2 Circumstances under which business rescue resolution may be taken. Board resolution to initiate business rescue is possible when the company is financially distressed. 12.3.3 Setting aside business rescue resolution or appointment of practitioner. Application to court. Affected persons can apply to court to set aside the resolution or appointment. Court's powers. Court has the authority to annul the resolution or the practitioner's appointment under specified conditions. 12.4 Court order to commence business rescue proceedings. 12.4.1 Application by affected person. Affected persons, shareholders, creditors, employees may apply to court to commence business rescue proceedings. 12.4.2 Grounds for court order. The court may grant a business rescue order based on financial distress or other relevant factors. 12.4.3 The order, a court order to commence business rescue proceedings must clearly specify the terms of business rescue. 12.5 Legal consequences of business rescue proceedings. 12.5.1 General moratorium on civil legal proceedings. Creditors are temporarily prohibited from initiating legal action against the company. 12.5 2 Protection of property interests. Secured creditors' interests are protected during business rescue. 12.5.3 Post-commencement finance. New financing may be provided to the company, and claims are ranked accordingly. 12.5.4 Employment contracts and employees. Employment contracts, employment agreements continue during business rescue. Unpaid remuneration, any unpaid wages prior to business rescue must be addressed. 12.5.5 Other contracts and agreements. Business rescue does not automatically terminate contracts but may modify terms. 12.5.6 Shareholders. Shareholders' rights remain unchanged, and they may participate in the proceedings. 12.5.7 Directors. Directors remain in control unless the court appoints a business rescue practitioner. 12.5.8 Creditors. Creditors' Committee. A committee may be established to represent creditors' interests. Voting rights. Creditors have voting rights on the business rescue plan. 12.6 The business rescue practitioner. 12.6.1 Qualifications of practitioner. Must meet specific legal qualifications to act as a business rescue practitioner. 12.6.2 Removal and replacement. Practitioners can be replaced under certain conditions. 12.6.3 Powers, duties and liabilities. Management. The practitioner takes over the management of the company. Investigation. The practitioner is responsible for investigating the company's affairs. Rescue plan. Development of a business rescue plan is one of the key duties. 12.6.4 Remuneration. The practitioner is compensated according to a prescribed scale. 12.7 The business rescue plan. 12.7.1 Prescribed contents. Part A. Background to the company and its financial distress. Part B. Proposals for rescuing the company. Part C. Assumptions and conditions for the proposals. 12.7.2 Publication of plan. The plan must be made public for stakeholder review. 12.7.3 Meeting to consider plan. A meeting is held to discuss and vote on the business rescue plan. 12.7.4 Effects of approval. Approval of the plan results in the implementation of rescue measures. 12.7.5 Effects of rejection. Rejection may lead to the termination of the business rescue process. 12.8 Termination of rescue proceedings. Business rescue proceedings can be terminated if the plan is not approved or if the company is unable to be rescued. Part B. Compromises. 12.9 Introduction to compromises. Definition. A compromise is an agreement between the company and its creditors to settle debts for less than the full amount owed. 12.10 Information to accompany compromise proposal. Part A. Background to the compromise. Part B. Detailed proposal for compromise. Part C. Assumptions and conditions of the proposal. 12.11 Other requirements. Projected balance sheet and statement, to show the company's financial status. Certificate by director or officer, certifying the proposal's authenticity. Majority adoption. A majority of creditors must approve the proposal for it to proceed. Court sanction. A court order is required to finalize the compromise and ensure its legal effect. Next page. 12.3 Resolution by Board of Directors to begin business rescue. Business rescue proceedings can be initiated by the Board of Directors through a formal resolution. The Companies Act, 2008 outlines the procedure and circumstances for initiating business rescue, as well as how proceedings may be stopped or set aside. 12.3.1 Procedure to commence business rescue by resolution. The Board of Directors must pass a resolution, file it with the Companies and Intellectual Property Commission, CIPC, notify affected parties, and appoint a business rescue practitioner. 12.3.1.1 Business Rescue Resolution by Board of Directors. The board may voluntarily resolve to begin business rescue under specific circumstances. The resolution is effective only when filed with the SIP, marking the official commencement of business rescue. A business rescue resolution cannot be adopted if liquidation proceedings have been initiated. Uncertain if initiated means commenced. Case study, Mouton v. Park 2000 development. The court determined that business rescue proceedings are considered to commence legally when the resolution is filed. Liquidation proceedings are initiated when the resolution to wind up is adopted, not when filed. In the case, the court held that the business rescue resolution was adopted in violation of S129(2)(a) of the Act, making it invalid. Case study, Checker Training Matters Proprietary, Limited v. KPPM Construction, Proprietary, Limited. The court interpreted initiated as not equating to commence, ruling that business rescue could proceed even if liquidation proceedings were issued but not served. 12.3.1 Through notification of affected parties and appointment of business rescue practitioner. Within 5 business days, or longer with Commission's permission, the company must notify affected persons, shareholders, creditors, trade unions, and employees of the resolution, the date it became effective, the grounds for the resolution. Notifications can be delivered electronically or by providing a summary of contents. The company must appoint a business rescue practitioner to oversee the proceedings within 5 business days. The practitioner must consent in writing to the appointment. 12.3.1.3 Consequences of non-compliance with prescribed procedures. If the company does not comply with the prescribed procedures, S129(5) declares the business rescue resolution to lapse and be a nullity. The company cannot file another resolution within 3 months unless approved by a court. Case study, Ex parte Van den Steen No. The court allowed substantial compliance with the notification requirements, deeming the business rescue resolution valid despite minor oversights. Case study, Advanced Technologies and Engineering Company, Proprietary, Limited. The court held that non-compliance with procedural requirements meant the resolution automatically lapses without the possibility of substantial compliance. Case study, Panama Properties, Proprietary, Limited v. Now NNO. The Supreme Court of Appeal clarified that even if the resolution lapses due to procedural non-compliance, business rescue does not automatically end. The company must apply to court to set aside the resolution, under S130. The court will decide if it is just and equitable to terminate the business rescue. Next. Page 12.3. 2 circumstances under which business rescue resolution may be taken. Reasonable grounds for financial distress. Directors must have reasonable grounds to believe that the company is financially distressed and has a reasonable prospect of rescue. Court involvement. Although the court is not involved in the initiation of business rescue proceedings, an affected person can apply to set aside the resolution, if these grounds are not met. Notice of decision not to adopt business rescue. If the board decides not to take a business rescue resolution, a notice must be sent to each affected person explaining the reasons for the decision. The notice must be in Form Call 123.3 and should be delivered within 5 business days of the decision. If the company does not intend to proceed with business rescue due to financial distress, the notice must still be sent, even if liquidation seems more likely. There is no specific penalty for non-compliance with the notification requirement under S129(7), though it may lead to civil liability. 12.3.3 Setting aside business rescue resolution, or appointment of business rescue practitioner. Court application. Affected persons may apply to court to set aside either the business rescue resolution, or the appointment of the business rescue practitioner. Grounds for setting aside the resolution. No reasonable basis for financial distress. No reasonable prospect of rescuing the company. Failure to comply with the procedures set in S129. Setting aside the resolution is not automatically void if it lapses due to procedural failure. An application must be made to the court for the resolution to be set aside. See Panama Properties v. Nell NNO. Business Rescue Practitioner. The court can set aside the appointment of the practitioner if the practitioner does not meet the requirements of S-138. The practitioner is not independent. The practitioner lacks the necessary skills for the company's rescue. No default security requirement. Unlike liquidators, business rescue practitioners are not required to provide security unless ordered by the court, which can be problematic if the practitioner is dishonest or incompetent. 12.3.3.1 Application to court to set aside resolution or appointment. Directors standing. Directors who voted for the resolution cannot bring an application to set it aside unless they can prove they acted in good faith, but later discovered misleading information. Procedure for application. The application must be served on the company, the commission, and all affected persons. Affected persons have the right to participate in the court hearing. 12.3.3.2 Procedure to set aside resolution or appointment. The court may require a report from the business rescue practitioner about the financial state of the company or its prospects of rescue before deciding to set aside the resolution or appointment. 12.3.3.3 Powers of court to set aside resolution or appointment. Grounds for court action. The court may set aside the resolution or appointment if one of the required grounds is proven and if it is just and equitable to do so. Panama Case Impact. The just and equitable standard for setting aside the resolution was effectively removed by the Supreme Court of Appeal. Liability for costs. If the court sets aside the resolution, costs may be imposed on directors who voted for it unless they acted in good faith, based on reliable information. Appointment of a new business rescue practitioner. If the appointment is set aside, the court will appoint a new practitioner, nominated by a majority of independent creditors. Independent creditors include creditors and employees who are not related to the company or its directors. Next page. 12.4 Court Order to commence business rescue proceedings. Court application by affected person. If directors do not resolve to begin business rescue, an affected person may apply to the court. The application must be served on the company, the commission, and all affected persons. Affected persons have the right to attend the hearing. Case study highlights. Cape Point Vineyards, Proprietary, Limited v. Pinnacle Point Group Limited. Regulation 124 requires delivering the entire application to affected persons, which may be impractical due to large numbers of shareholders. Court advised seeking permission for substituted service or only sending notifications. Kalahari Resources, Proprietary, Limited v. ArcelorMittal, S.A. Despite concerns about Regulation 124, compliance is necessary unless declared invalid. Court allowed notifying recipients of document availability instead of sending the full document. Impact of liquidation proceedings. A business rescue application can still be made after liquidation proceedings have commenced. If granted, business rescue suspends liquidation until the proceedings end. Standard Bank of South Africa Limited v. Gas 2 Liquids, Proprietary, Limited. The application for business rescue must be served on relevant parties before the liquidation is suspended. Richter v. Absa Bank Limited. Business rescue application may be brought even after a final liquidation order, as long as liquidation is not completed. Business rescue commencement commences when the application is made and served, although delays may occur in appointing a business rescue practitioner. The court may initiate business rescue without an application, particularly during liquidation or security enforcement. 12.4.2 Grounds for court to order commencement of business rescue. Criteria for application. Company must be financially distressed or have failed to meet employee obligations, for example, UIF, medical aid. Court may order business rescue if it's just and equitable for financial reasons. There must be a reasonable prospect of rescuing the company. Case law insights. Gormley v. West City Precinct Properties. A company already insolvent does not meet the definition of financially distressed for business rescue. Oakdean Square Properties v. Farm Bothfontein. Commercial insolvency qualifies for business rescue, however, insolvency impacts the rescue prospects. Tire Corporation Cape Town v GT Logistics. Insolvency does not automatically preclude business rescue if it is just and equitable for financial reasons. Reasonable prospect of rescue. Southern Palace Investments. A concrete business rescue plan with objective details is required, addressing costs, resources and the plan's feasibility. Oak Dean Square Properties. A reasonable prospect must be grounded in facts and not speculation. Shoprite Checkers v Berryplum Retailers. Major creditor opposition is relevant, however, it shouldn't be unreasonable if it impacts rescue prospects. 12.4.3 Court Order for Business Rescue. Court's role. If the court orders business rescue, it may appoint an interim business rescue practitioner, pending creditor approval. The practitioner convenes a meeting of creditors to approve their appointment. Notification requirement. The company must notify affected persons within 5 business days after the order placing it under supervision. Failure to grant business rescue. The court may dismiss the application and may place the company in liquidation instead. Next page. 12.5 Legal consequences of business rescue proceedings. Stay on civil legal proceedings. Most civil proceedings are paused until the end of the business rescue process. Restricted disposal of company property. The company's assets cannot be sold or disposed of freely. Refinancing facilitated. Company assets can secure loans, but employee obligations are treated as post-commencement finance with preferential claims. Employment contract protection. Employment contracts are safeguarded during the business rescue. Suspension or cancellation of a contracts. Certain contracts may be suspended or cancelled. Share status protection. The status of issued shares cannot be altered. Shareholders may only participate if their interests are impacted. Directors' cooperation. Directors must cooperate with the business rescue practitioner. Section 154(2) of the Companies Act. A creditor cannot enforce a debt owed before the business rescue started, except as stated in the approved business rescue plan. Iravin Construction Case. A company in liquidation that made a void payment before entering business rescue was not liable for repayment in business rescue since the debt was pre-business rescue. 12.5.1 General moratorium on civil legal proceedings. Automatic stay on legal proceedings. Legal actions, including enforcement actions against the company, are paused unless written consent from the business rescue practitioner, court permission, with conditions, set off against a claim by the company, criminal proceedings or regulatory authority actions. Regulatory authority exceptions. Regulatory authorities, like SARS or the Financial Sector Conduct Authority, may continue proceedings if they give written notice to the practitioner. Legal proceedings definition. LA Sport case. It was held that contract termination is not considered a legal proceeding. Clouthier Murray case. The Supreme Court ruled that cancellation of a contract is not a legal proceeding. Contract cancellation. If a contract has been cancelled, before or after business rescue, the company is not lawfully in possession of the other party's property, and the moratorium on legal proceedings does not apply. Court leave for legal proceedings. Courts must grant permission to institute or continue legal actions against a company in business rescue before initiating proceedings. Guarantees and sureties. A guarantee or surety provided by the company in business rescue cannot be enforced against the company without court permission. Investec Bank case. It was held that the moratorium applies to the company itself, but creditors can enforce debt from a third-party surety during business rescue, prior to a rescue plan's approval. Prescription. The period of business rescue does not count towards the prescription period for claims against the company. Next page. 12.5.2 Protection of property interests, including interests of pre-business rescue secured creditors. Restrictions on property disposal. The company can only dispose of property if it's part of the ordinary business activities. It is a good faith transaction with the prior written consent of the business rescue practitioner. It is in accordance with the approved business rescue plan. Property possession. If a person lawfully possesses company property under an agreement made before business rescue, they can continue exercising their rights under that agreement, subject to Section 136. No one can exercise rights over the company's property unless written consent is obtained from the business rescue practitioner. Sale of secured property. The company does not need creditor permission to sell property if the sale proceeds will fully pay the creditor. If the property is subject to a retention of ownership agreement and sold without the owner's consent, the ownership does not transfer, and the true owner may reclaim the property. Case study: Pre-Business Rescue Secured Debts. National Union of Metalworkers case. The company's business rescue practitioners sold assets secured by a creditor, bank, without the bank's prior consent. The court emphasized Section 134 of the Companies Act, which protects pre-business rescue secured creditors by preventing the removal of their security without their consent or full repayment of the debt. The court confirmed that the protected status of secured creditors aligns with common law and does not grant preferential status to post-commencement finance (PCF) creditors over pre-business rescue secured creditors. The court ruled that employees' PCF claims did not take precedence over the bank's claims. 12.5.3 Post-commencement finance and ranking of claims. Post-commencement finance (PCF). Section 135(2) allows the company to use unencumbered assets as security for post-commencement loans. PCF creditors, both secured and unsecured, have preference over all unsecured claims, including those of pre-business rescue unsecured creditors. Employment-related payments. Employment-related payments due during business rescue proceedings are treated as PCF and must be paid before post-commencement financiers. The practitioner's remuneration, business rescue costs, and employee claims take priority over post-commencement finance claims. Employees with unpaid salaries when business rescue started become preferred unsecured creditors. Impact of liquidation on post-commencement claims. If liquidation replaces business rescue proceedings, post-commencement financiers and employees retain their preferential rights. Case study: Preferential rights in liquidation after business rescue. Netbank Limited case. If business rescue is replaced by liquidation, the business rescue practitioner's claim for unpaid remuneration ranks ahead of post-commencement financiers and employees' claims in the free residue of the estate. The practitioner's claim does not rank ahead of secured creditors, but if the sale proceeds from a secured asset exceed the creditor's claim, the surplus falls into the free residue, which will be available for distribution after satisfying the practitioner's claims. Next. Page 12.5.4 Employment contracts and employees. 12.5.4.1 Employment contracts. Effect of business rescue. Business rescue proceedings do not affect existing employment contracts. Employees continue under the same terms and conditions, but the company and employees can agree to new terms under applicable labor legislation. Retrenchment: any retrenchment, even if part of the business rescue plan, must comply with relevant labor laws. Case study: NUMSA OBO Members v. SAR, SOC, Limited. The Labor Court examined the relationship between Section 189A of the Labor Relations Act, LRA, and Section 136 of the Companies Act. The court ruled that Section 136(1) does not empower a business rescue practitioner to retrench employees without a business rescue plan. Any attempt to begin a retrenchment process before the business rescue plan is in place is procedurally unfair. 12.5.4 To unpaid remuneration before business rescue proceedings. Employees with unpaid salary or other employment-related payments at the start of business rescue proceedings become preferred unsecured creditors. Medical schemes, pension funds, and provident schemes with debts owed by the company at the start of business rescue are also unsecured creditors. 12.5.4.3 Employees Committee. Employees may form a committee of representatives to ensure their interests are represented during business rescue proceedings. The business rescue practitioner must convene a meeting with employees or their representatives within 10 business days to inform them of the company's future, and discuss the appointment of the employees committee. The committee can consult with the practitioner, but cannot give instructions to them. Next. Page 12.5.5 Other contracts and agreements. Suspension of contractual obligations. The business rescue practitioner may suspend, partially, entirely, or conditionally, the company's obligations under contracts entered before the commencement of business rescue, if these obligations become due during the proceedings. Exceptions: employment contracts and contracts covered under Sections 35A and 35B of the Insolvency Act, relating to liquidation, are not subject to suspension. The other party may only claim damages for any suspension or cancellation, not terminate the contract. Case study: BP Southern Africa, Proprietary, Limited v. Intertrans Oil SA, Proprietary, Limited. Reciprocal obligations: if the contract involves reciprocal obligations, the creditor can't demand specific performance during suspension, but retains the right to seek cancellation and return of property. Court application for cancellation. A business rescue practitioner may apply to the court to cancel any contractual obligation, except employment contracts, and those under Insolvency Act Sections 35A or 35B, on just and reasonable terms. However, no guidance is provided on the specific grounds for such cancellations or what factors the court should consider. 12.5.6 Shareholders. 12.5.6.1 No change in rights. No changes to the classification or status of issued securities during business rescue unless authorized by the court, included in an approved business rescue plan. 12.5.6 2 Participation. Shareholders are affected persons and have the right to be notified and participate in business rescue and court proceedings. Voting on business rescue plan. Shareholders whose rights will be altered by the plan, for example, changing the company's memorandum of incorporation or issuing new shares, may attend the meeting and vote. Shareholders may propose a new plan if the original plan is rejected. Shareholders can also make offers to take over voting interests of creditors or shareholders opposing the plan. 12.5.7 Directors. 12.5.7.1 Duties and liabilities of directors. Directors must cooperate with the business rescue practitioner and continue performing their duties under the practitioner's authority and instructions. Directors must deliver company records to the practitioner, provide a statement of the company's affairs within 5 business days, relieve from certain duties. Directors are relieved from most duties under Section 76 and liabilities under Section 77 if acting under the practitioner's reasonable instructions. Directors remain bound by Section 75, disclosure of personal financial interests. Directors remain personally liable for acts such as acting without authority, conducting business in a manner prohibited by Section 22(1), for example, recklessness or fraud. Void acts. Acts requiring the practitioner's approval are void if done without such approval. 12.5.7 2 Removal of a director. The business rescue practitioner can apply to the court for a director's removal if the director fails to comply with the Companies Act provisions during business rescue, hinders the business rescue process. A director can be declared delinquent or placed under probation during the business rescue process. 12.5.8 Creditors. Creditors, including employees with unpaid remuneration, have the right to be notified and participate in business rescue proceedings. 12.5.8.1 Creditors Committee. Within 10 days of appointment, the practitioner must convene a meeting of creditors to inform them of the company's future and allow them to prove their claims. Creditors may form a committee to represent their interests, which the practitioner must consult during the business rescue plan's development. The committee cannot instruct the practitioner. 12.5.8 2 Voting rights. Creditors vote based on the full value of their claim against the company, whether secured or unsecured. Concurrent creditors with subordinated claims vote based only on the amount they would likely receive in liquidation. The voting interest must be valued by an independent expert, not the practitioner. Decision validity. A decision is valid if supported by the majority of independent creditors. Next. Page 12.6 The Business Rescue Practitioner. Overview. The Companies Act, 2008 outlines the appointment, powers, duties, removal, and remuneration of a business rescue practitioner. 12.6.1 Qualifications of Business Rescue Practitioner. Initially aimed at creating a regulated profession, but the requirement was removed by the Companies Amendment Act. Qualification criteria. 1. Be a member in good standing of a legal, accounting, or business management profession accredited by the Commission. 2. Be licensed by the Commission to practice. 3. Not subject to probation under S. 162(7). 4. Not disqualified from acting as a director under S. 69(8). 5. Not have a relationship compromising integrity, impartiality, or objectivity. 6. Not be related to someone who has a compromising relationship. 12.6. 2. Removal and replacement of business rescue practitioner. A business rescue practitioner can only be removed by court order under S. 130 or S. 139. Grounds for removal, S. 139(2). Incompetence or failure to perform duties, failure to exercise proper care in functions, engaging in illegal conduct, no longer meeting appointment requirements, conflict of interests or lack of independence, incapacitation and inability to perform duties. Competence. Incompetence grounds for removal, but competence is not a requirement for appointment. Appointment of new practitioner. If the practitioner dies, resigns, or is removed, a new one must be appointed by the company or the nominating creditor. 12.6.3 Powers, duties, and liability of business rescue practitioner. Powers and duties. Takes over full management of the company, including the ability to delegate powers, can remove pre-existing management and appoint new members, must inform regulatory authorities of the company's business rescue status. Investigation. Must investigate the company's affairs to assess the chance of successful rescue. If the company is unlikely to be rescued or financially distressed, the practitioner must apply for liquidation. Must inform the court and affected persons if business rescue proceedings are no longer applicable. Should investigate voidable transactions, reckless trading, fraud, and misappropriated assets. Development of rescue plan. Developing and implementing a business rescue plan is a key responsibility. Liability. The practitioner is liable for breaches of duties under SS 75 to 77, liable for acts performed in bad faith or gross negligence, but not otherwise for actions performed in good faith. As an officer of the court, must report to the court as required. 12.6.4 Remuneration of business rescue practitioner. Basic remuneration, set according to a tariff prescribed by the minister, determined at the time of appointment. Contingency fees. Can enter into agreements for additional fees, if a rescue plan is adopted or specific results are achieved. Requires approval by the majority of creditors and shareholders. Creditors/shareholders who voted against can apply to the court to cancel the agreement, if it is unreasonable or not equitable. Reimbursement for costs. Entitled to be reimbursed for actual, reasonable costs incurred during business rescue. Costs should be necessary for fulfilling functions, not including regular operational costs. Unpaid remuneration. In a liquidation, the practitioner must prove a claim for unpaid remuneration as any other creditor, paid out of the free residue. Next. Page 12.7 The Business Rescue Plan. Duty of the practitioner. The business rescue practitioner is responsible for preparing a business rescue plan, but must consult with creditors, affected persons, and the company's management during the process. Section 151. 12.7.1 Prescribed contents. The rescue plan must provide all information required for affected persons to decide whether to accept or reject it. Section 152 divides the plan into 3 parts and requires a certificate at the end. Substantial compliance. The Court in Commissioner of South African Revenue Services v. Beginsel held that substantial compliance with Section 152 suffices, as the specifics may not apply in all cases. There is no remedy or sanction for failure to comply substantially with these requirements. _ 12.7.1.1 Part A. Background. Financial situation. The plan must include details about the company's financial state. List of material assets, indicating which are held as security by creditors. List of creditors and their classification: secured, statutory preferred, concurrent. Dividend expectations if the company were liquidated. List of holders of issued securities. Written agreement on the practitioner's remuneration. Statement on informal proposals from creditors. _ 12.7.1.2 Part B. Proposals. Proposals to overcome issues, details of proposed measures to manage debt and assist the company. Moratorium on debt payments, post-business rescue. Release or conversion of debts into equity. Role of the company and treatment of existing contracts. Assets available for creditor payment. Order of preference in creditor payments. Comparison of creditors' benefits if the company is rescued versus liquidation. Effect on the holders of issued securities. _ 12.7.1.3 Part C. Assumptions and conditions. Conditions for implementation. The plan must include conditions required for the plan to operate, impact on employees and conditions of employment, for example, retrenchment, circumstances when the business rescue plan ends, projected financial statements, balance sheet, income/expense statement, for the next 3 years. _ 12.7.1.4 Certificate. The plan must conclude with a certificate by the business rescue practitioner stating the accuracy of the information and that projections are made in good faith. _ 12.7. To publication of the plan. The plan must be published within 25 business days of the practitioner's appointment, unless extended by court or creditor agreement. No specific remedy is provided for failure to meet the publication deadline. _ 12.7.3 Meeting to consider business rescue plan. Creditor meeting, convened within 10 business days of the plan's publication. All affected persons must be notified at least 5 business days before. The practitioner must explain the plan and assess the company's chance of being rescued. Employees' representatives must be allowed to address the meeting. Approval process. The plan is approved if more than 75% of voting creditors and at least 50% of independent creditors approve. If shareholder rights are altered, shareholder approval is also required. _ 12.7.4 Effects of approval. Binding. Once approved, the plan is binding on the company, creditors, and security holders, regardless of voting outcomes. Surety effects. The effect on sureties is unclear but may remain liable unless specified in the rescue plan. Implementation. The practitioner must take steps to fulfill any conditions and implement the plan. Notice of substantial implementation must be filed once the plan is mostly implemented. _ 12.7.5 Effects of rejection. Rejection. If the plan is rejected, the practitioner may seek approval for a revised plan or apply to court to set aside the vote. Alternatively, affected persons can request a revised plan or court intervention. In certain cases, voting interests can be purchased to gain enough support for approval. Failure to act. If no actions are taken, the practitioner must file a termination notice with the Commission. Next page. 12.8 Termination of rescue proceedings. Business rescue proceedings in the Companies Act, 2008 are typically designed to last no longer than 3 months, but this period often extends to 6 to 18 months in practice. If proceedings cannot be completed within 3 months, the business rescue practitioner may apply to the court for more time, or opt to deliver a monthly progress report to affected persons and the court, if initiated by court order, or the Commission. Termination can occur in the following ways as per Section 132(2). Court order setting aside the resolution/order that initiated proceedings. Court converting the rescue into liquidation proceedings. Business rescue practitioner filing notice of termination with the Commission. A business rescue plan being adopted and substantially implemented. Business rescue plan being rejected without further steps being taken, per Section 153(5). 12.9 Compromises. Introduction. Compromise refers to an agreement between a company and its creditors where creditors agree to accept less than the full amount owed, for example, 50% of their claim. Under the Companies Act, 1973, compromises were court-driven from start to finish, with the court sanctioning the arrangement. Companies Act, 2008 introduced a simplified compromise process, where the court sanctions the compromise only after it has been agreed upon by all parties, removing court involvement in initiating or negotiating the compromise. The compromise procedure is not applicable if the company is in business rescue proceedings or is covered by Section 128(1) of the Companies Act, 2008. Proposals for a compromise, Section 155(2), who may propose a compromise. A company's board of directors. The liquidator of the company, if the company is in liquidation. To whom can the compromise be proposed? All the company's creditors. All members of any class of the company's creditors. How to propose a compromise. A copy of the proposal and a notice for a meeting to consider the proposal must be delivered to all creditors or members of the relevant creditor class, whose names and addresses are known to the company or can be reasonably obtained. The Commission must also be notified. Next page. 12.10 Information to accompany a proposal of compromise. A proposal for compromise must contain sufficient information to help creditors decide whether to accept or reject the proposal, as outlined in Section 155(3). The proposal is divided into 3 parts. Part A, Background. Part B, Proposals. Part C, Assumptions and Conditions. 12.10.1 Part A, Background to the proposal, Section 155(3)(a), Material Assets List. Complete list of assets, including details on assets held as security by creditors. Creditors List. Complete list of creditors, specifying secured, statutory preferred, and concurrent creditors, along with those who have proved claims, relevant in liquidation. Probable dividend in liquidation. Estimated amount creditors would receive if the company was liquidated. Holders of securities. Complete list of security holders and the proposal's impact on them. Informal proposals. Whether any informal proposals have been made by creditors. Note: no valuation of assets is required, though it could assist creditors' decision-making. 12.10.2 Part B, Details of Proposal, Section 155(3)(b), Debt Moratorium, Nature and duration of any proposed debt moratorium. Debt relief. Extent to which debts are released or converted to equity. Contract treatment. How existing contracts are treated and the company's ongoing role. Property for payment. The property of the company to be used to pay creditors' claims. Order of preference. Order in which creditors will be paid from the property proceeds. Comparison with liquidation. Benefits of adopting the proposal compared to liquidation. 12.10.3 Part C, Assumptions and Conditions of the Proposal, Section 155(3)(c), Conditions for Operation and Implementation, Conditions to satisfy before the proposal comes into effect and is fully implemented. Effect on employees. The impact on the number of employees and their employment terms and conditions. Projected financials. Projected balance sheet. Projected income and expenses for the next 3 years. 12.11 Other requirements. 12.11.1 Projected financials. Projections must include a notice of significant assumptions and may include alternative projections based on varying assumptions. 12.11.2 Certificate by authorized director/officer. The proposal must conclude with a certificate from an authorized company officer stating that all factual information in the proposal is accurate and up to date. Projections are made in good faith based on the provided assumptions. 12.11.3 Majority required for adoption, Section 155(6). The proposal is adopted if supported by a majority of creditors, at least 75% by value, present and voting at the meeting, whether in person or by proxy. No specified quorum, meaning a small number of creditors can adopt the proposal, but the court will consider this when deciding whether to sanction the proposal. 12.11.4 Court sanction of adopted proposal, Section 155(7). After adoption, the company may apply to the High Court for sanctioning. The court may sanction the proposal if it finds it just and equitable, considering factors like the number of creditors who supported the proposal and, if in liquidation, a report by the master. No indication whether the court will sanction the proposal until after adoption, which can lead to wasted time and resources. 12.11.5 Filing requirements and effect of sanctioned compromise, Section 155(8). A copy of the court order sanctioning the compromise must be filed within 5 business days and attached to the company's MOA. Once sanctioned, the compromise is binding on all creditors or relevant classes. A significant issue is the lack of moratorium between the proposal submission and court sanction, which could allow creditors to pursue legal action. The compromise does not affect any surety liabilities. A creditor receiving less than the full amount can claim the difference from the surety. Next page. Chapter 13. 13.1 Appointment and independence of an auditor. Objective: ensure auditors' independence from the company to maintain objectivity in auditing financial statements, Section 92. Disqualifications. Directors, employees, or consultants involved in financial record maintenance or financial statement preparation for over a year. Regular providers of accounting or bookkeeping services. Individuals involved in conflicting roles within the company during the preceding 5 financial years. Auditors must be independent, as confirmed by the company's audit committee. Who can be appointed as an auditor? Must be a registered auditor. Cannot be a director, company secretary, prescribed officer, or employee/consultant involved in financial record-keeping or statement preparation for over a year. Must not regularly perform accounting/bookkeeping duties or related secretarial work for the company. Must be acceptable to the audit committee regarding independence. Public and state-owned companies and certain private companies must appoint an auditor annually. Reappointment of retiring auditor. A retiring auditor may be reappointed automatically unless they no longer meet the qualifications. They are unwilling to accept the reappointment. They are required to cease their duties per Section 92. The audit committee objects. There's a notice for an intended resolution to appoint another auditor. If no reappointment occurs, the directors must fill the vacancy within 40 business days. Auditor's engagement letter. The engagement letter sets the terms of the auditor's appointment and details audit objectives, responsibilities, and audit planning arrangements. Case study: Thoroughbred Breeders Association v. Price Waterhouse, 1999. Facts: auditors were sued for failing to detect an employee's theft of funds. Court's ruling: auditors were found negligent for failing to detect the fraud early in the audit, leading to significant losses. 13.1 2 Enhanced accountability and transparency. Chapter 3 focuses on ensuring good governance in public and state-owned companies, but some private companies may also be subject to certain provisions, for example, audit requirements. Private companies must appoint an auditor if required by their Memorandum of Incorporation, MOI, or by the Companies Act. Legal requirement for an audit committee and company secretary. Public companies and state-owned companies must appoint an audit committee and company secretary to ensure good governance and transparency. 13.2 Which companies' financial statements are subject to an audit? Public and state-owned companies are required to have audited financial statements annually. Private companies may be required to appoint an auditor based on activity criteria, if the company holds assets in fiduciary capacity exceeding $5 million. Size criteria, based on the public interest score. Private companies, activity criteria for appointment of auditor. Activity test, if a private company holds assets in fiduciary capacity, for example, in trust for third parties, exceeding $5 million, an auditor is required. Example, estate agencies, where trust funds are held, might be subject to other regulations requiring an audit. Private companies, size criteria for appointment of auditor. Public interest score. Companies with a score of 350 or more must appoint an auditor. Companies with a score between 100 and 350, if their financial statements are internally compiled, must also appoint an auditor. Public interest score calculation. Employee count, 1 point per employee. Third-party debt, 1 point for every or 1 million in third-party debt. Turnover, 1 point for every or 1 million in turnover. Beneficial interest, 1 point for each individual holding a beneficial interest in the company's issued securities. Objective, ensure that significant private companies are subject to external audits, especially those with higher turnover or workforce. Next page. Here are the detailed study notes based on the provided content. 13. 2.3 Private companies, exemption from audit and independent review. Exemption criteria. A private company does not require an audit or independent review if it does not meet the activity or size criteria for an audit, as discussed earlier. All holders of beneficial interests are also directors of the company. Owner-managed private companies. Owner-managed private companies. If an audit is required due to meeting activity or size tests, the exemption does not apply. The exemption only applies to the independent review requirement for owner-managed companies, not to the audit requirement. 13. 2.4 Summary of which companies should appoint an auditor. Companies required to appoint an auditor. Public companies. State-owned companies. Private companies. Fiduciary capacity. If the company holds assets exceeding $5 million in fiduciary capacity for unrelated persons. Public interest score of 350 or more. Public interest score between 100 and 349, with internally compiled financial statements. MOI requirement. A company may be required to appoint an auditor based on its MOI. Voluntary appointment. Companies may also appoint an auditor through a directors' or shareholders' resolution. Non-profit companies, those incorporated by the state, an organ of state, or international entities for regulatory/statutory purposes. Exemption from audit. Owner-managed private companies that are not required to undergo an audit under the regulations require an independent review instead. 13. 2.5 Audit and Independent Review Requirement Summary, Table 13.1 Profit Companies Audit, or Independent Review. State-owned companies audit by a registered auditor. Public companies listed on an exchange audit by a registered auditor. Public companies not listed on an exchange audit by a registered auditor. Private companies with public interest score of 350 or more or hold assets over $5 million in fiduciary capacity audit by a registered auditor. Private companies with public interest score 100 to 349 independent review by a registered auditor, or CASA, if financial statements are externally compiled. Audit by a registered auditor if financial statements are internally compiled. Exemption does not apply to owner-managed companies. Private companies with public interest score less than 100 independent review by registered auditor, or CASA, or person qualified as accounting officer of a close corporation. Owner-managed private companies exempt from independent review requirements, if not required to appoint an auditor. 13. 2.6 Audit requirement for companies holding assets in fiduciary capacity. Fiduciary capacity. Companies holding assets exceeding $5 million in fiduciary capacity for persons unrelated to the company must undergo an audit. Example, a company holding money to invest on behalf of others must have an audit to protect investors from theft or fraud. Rationale, the audit requirement is designed to protect investors from fraud, theft, or misappropriation of funds, providing an additional layer of accountability and transparency for companies handling third-party funds. Next page. Here are the detailed study notes based on the provided content. 13.3 Independent Review, and the role of the independent accounting professional. Independent review requirement. Certain companies must have their financial statements independently reviewed even if not audited. Private companies generally require independent reviews, except if exempt. Voluntary audit. Companies that voluntarily opt for an audit do not need an independent review. Independent review criteria. Public interest score greater than or equal to 100. The review must be performed by a registered auditor or an approved professional in terms of the AP Act. Public interest score less than 100. An independent accounting professional may conduct the review. Independent accounting professional definition. A registered auditor as per the AP Act, or a member of an accredited professional body under Section 33 of the AP Act, or qualified to be an accounting officer of a close corporation under Section 61, 2, and 4 of the Close Corporations Act. Independence requirements. The independent accounting professional must not have a financial interest in the company, not be involved in day-to-day management for the past 3 years, not be a prescribed officer or full-time employee of the company for the past 3 years, not be related to any of the above persons, not have been involved in preparing the financial statements. Review process. Only registered auditors and CAs, SA, can perform independent reviews for companies with a public interest score above 100. Reviews must be carried out by an independent professional who has not participated in the preparation of financial statements. Independence concerns may arise if an individual from the same firm prepares the financial statements and conducts the review. The firm must assess whether independence is impaired before accepting the appointment. 13.4 Resignation of auditors and vacancies. Resignation. Auditor's resignation is effective when the notice is filed. Vacancy in auditor's office. If there was one auditor, the company's board must appoint a new auditor within 40 business days. If there were multiple auditors, the remaining auditor continues to act as the auditor. Appointment process. The board must propose a new auditor to the audit committee within 15 business days of a vacancy. If the audit committee does not reject the proposed auditor within 5 business days, the board can appoint the proposed person. Firm changes. A change in the composition of a firm does not create a vacancy unless less than half of the original members remain. 13.5 Rotation of auditors. 5-year rule. Section 92 of the Companies Act, 2008 mandates that an individual cannot serve as an auditor or designated auditor for more than 5 consecutive financial years. This rule applies to individual auditors, not the firm as a whole. Post-rotation. After serving for 2 consecutive terms, an individual cannot be reappointed as auditor until at least 2 further financial years have passed. Joint auditors. For companies with 2 or more joint auditors, the rotation must be managed to ensure not all auditors rotate in the same year. 13.5.1 Rotation of auditors of public interest entities, PIEs, Mandatory Rotation Rule, MAFR. Starting the 1st of April 2023, all public interest entities, PIEs, must rotate their auditor after 10 consecutive financial years. The rotated auditor can only be reappointed after 5 financial years. PIE definition. Includes all listed entities and entities defined as public interest entities by regulation or legislation. Includes entities required by regulation or legislation to adhere to independence requirements similar to those of listed entities. Examples of PIEs. South African banks not listed. Strata, South African Central Securities Depository. Johannesburg Stock Exchange. pension funds, medical schemes, and unit trust schemes. Underscore. 13.6 Rights and restricted functions of auditors. Auditors' rights. Access to records. Auditors have the right to access accounting records, books, and documents of the company. Information requests. Auditors can require information and explanations from directors or officers for performing their duties. Access to subsidiaries. Auditors of a holding company can access financial statements and documents of its subsidiaries. Attend shareholders' meetings. Auditors have the right to attend general shareholders' meetings and be heard on any matters related to their duties. Court application. Auditors may apply to the court to enforce their rights, if obstructed by the company or its officers. Auditors' restrictions. Conflict of interest. Auditors cannot perform services for a company that would place them in a conflict of interest, as determined by the IRBA or the company's audit committee. AP Act provisions. Only a registered auditor may engage in public practice or hold themselves out as an auditor. Non-registered persons are prohibited from performing auditing services or using terms like public accountant or certified public accountant. Registered auditors' responsibilities, Section 44 of AP Act. Auditors must perform their duties free of restrictions and in compliance with auditing standards. Auditors must ensure proper accounting records are kept and all assets and liabilities are recorded accurately. They must obtain necessary information and documents for proper audit performance. Auditors must report any reportable irregularities under Section 45, if applicable. Auditor's opinion. An auditor must express an opinion that the financial statements fairly represent the entity's financial position, if specific criteria are met, including adequate accounting records and no material restrictions during the audit process. Next page. Here are the detailed study notes based on the provided content. 13.7 Independent Regulatory Board for Auditors, IRBA, Establishment and Purpose. The Auditing Profession Act, AP Act, establishes the IRBA with the following primary functions. Promote integrity, investigates alleged improper conduct, and conducts disciplinary hearings, imposing sanctions as necessary. Public protection, protects the public in dealings with registered auditors. Professional standards, prescribes standards for qualifications, competence, ethics, and conduct of registered auditors. International engagement, participates in international bodies developing auditing standards and promoting the auditing profession. Publications, publishes a journal, newsletters and circulars providing information and guidelines for the profession. Education and research, encourages education and research in auditing-related matters. Accreditation, accredits professional bodies. Registration, oversees the requirements for the registration of auditors. Authority in education, acts as the final authority on the education, training and professional development of auditors. Underscore. IRBA's role and mission. IRBA overview. The IRBA is the statutory body regulating public accountancy in South Africa, focusing on protecting public financial interests by ensuring qualified individuals are admitted to the auditing profession. Corporate mission. Mission, protect the financial interests of the South African public and international investors by ensuring high-quality auditing services and adherence to ethical standards. Vision. The IRBA aims to be an internationally recognized regulator of the auditing profession and other assurance services relevant to South Africa. Functions of the IRBA. Ethical financial sector, aims to create an ethical, value-driven financial sector that promotes investment, market confidence, and sound practices. International standards, develops and maintains internationally comparable auditing and ethics standards. Competence framework, establishes a framework for education, training and ongoing competence of auditors. Auditor registration, registers auditors meeting registration requirements. Compliance monitoring, monitors registered auditors' compliance with professional standards. Investigations and actions, investigates improper conduct and takes appropriate actions against registered auditors. Stakeholder relationships, develops relationships with stakeholders to enhance performance, accountability and public confidence. Underscore. IRBA Permanent Committees, Section 20 of AP Act. The IRBA must appoint the following permanent committees. Auditor Ethics Committee, in accordance with Section 21 of the AP Act. Auditing Standards Committee, in accordance with Section 22 of the AP Act. Education, Training and Professional Development Committee. Investigating Committee. Disciplinary Committee. Next page. Here are the detailed study notes based on the provided content. 13.8 Audit Committees. Requirement for Audit Committee. Public companies, state-owned enterprises, or any company voluntarily deciding to have an audit committee must elect at least 3 members. Exemption: a company that is a subsidiary of another company with an audit committee does not need to elect its own audit committee if the parent company's committee performs the required functions. 13.8.1 Composition of an Audit Committee. Member eligibility. Directors only. Each member must be a director of the company. No day-to-day management. Members must not be involved in the company's day-to-day management or have been involved in the last 3 financial years. Exclusion of prescribed officers/executives. Members cannot be prescribed officers or full-time executive employees of the company or any related/interrelated company, nor have been such within the last 3 years. Independence restrictions. Non-executive and independent members should be non-executive independent directors. No material supplier/customer relationship. Members cannot be significant suppliers or customers whose relationships could compromise their objectivity. Voting rights limitation. Members cannot hold more than 5% of the voting rights in the company or its holding company. Appointment of additional members. The board may appoint a non-director with financial knowledge and experience to enhance the committee's ability to perform its duties. The appointee must be eligible and not disqualified under the Act. 13.8 2 Duties of an Audit Committee. Report preparation. The Audit Committee must prepare a report for the annual financial statements including 1. A summary of how the Audit Committee carried out its functions. 2. Confirmation of the Audit Committee's satisfaction regarding the independence of the auditor. 3. Comments on the financial statements, accounting practices, and internal financial controls. Additional duties, Section 94(7) of the Companies Act. Nominate an auditor. Nominate a registered auditor who is independent of the company. Determine auditor's fees. Decide on the auditor's fees and terms of engagement. Compliance with legislation. Ensure auditor appointment complies with the Act and related laws. Non-audit services. Determine the extent of non-audit services the auditor can provide and pre-approve any agreements for non-audit services. Address concerns. Receive and address concerns or complaints regarding accounting practices and internal audits. Content or auditing of financial statements. Internal financial controls. Related matters. Board submissions. Make submissions to the board on accounting policies, financial control, records, and reporting. Risk management. Develop and implement a policy for evaluating and improving risk management, control, and governance processes. Auditor independence considerations. The Audit Committee must confirm that the auditor does not receive remuneration other than for auditing or permitted services. Consultancy/advisory work. Evaluate whether previous consultancy or advisory work affects the auditor's independence. Compliance with IRBA guidelines on auditor independence. Appointment of auditor. A public company may appoint a different auditor at its AGM than the one nominated by the Audit Committee, but the appointment is only valid if the committee is satisfied with the proposed auditor's independence. Example: Aspen Pharmacare Holdings Ltd.'s Audit and Risk Committee Report, 2017 Summary of Activities. 1. Engagement with external auditors. Nominated and recommended the appointment of an independent auditor. Determined the auditor's fees and terms of engagement. Ensured compliance with the Companies Act, 2008. Pre-approved any material non-audit services. 2. Compliance with the Companies Act. Prepare the report in compliance with S-94-7F of the Companies Act. Handle concerns related to accounting practices, internal audits, financial statements and internal controls. Made submissions to the Board on accounting policies and financial controls. 3. Internal financial controls. Assessed the internal financial controls and confirmed no material breakdowns during the year. Confirmed the effectiveness of the internal audit function. Ensured a combined assurance model was applied to avoid gaps and overlap. 4. Risk management oversight. Monitored the implementation of the group's risk policy and plan. Reviewed the activities and reports from the Group Executive Risk Forum. Ensured that internal and external audit reports on financial, IT, and internal controls were reviewed. 5. Financial Director expertise. Confirmed the expertise of the Deputy Group Chief Executive and the finance function. Evaluated the integrity of financial reports and sustainability disclosures. Next. Page 13.9 Mandatory appointment of Company Secretary. Public companies and state-owned enterprises must appoint a company secretary. Other companies must appoint a company secretary if required by their Memorandum of Incorporation, MOI. Role: Company Secretary is the Chief Administrative Officer of the company. Qualification requirement: directors must ensure the person appointed is suitably qualified with necessary experience. Duties of the Company Secretary. Guidance to directors: provides guidance on duties, responsibilities, and powers. Compliance awareness: informs directors of relevant laws affecting the company. Reporting non-compliance: reports to the board on any non-compliance with the Act. Minutes management: ensures minutes of meetings, shareholders, board, committees are properly recorded. Financial statement certification: certifies in the company's financial statements if returns and notices are filed correctly. Discharge of functions under Section 33(3). Carries out other specific functions as per the Act. Disqualification of Company Secretary. Court prohibition: a person prohibited from being a director or declared delinquent by the court. Insolvency: if the person is an unrehabilitated insolvent. Regulatory prohibition: if public regulations prohibit being a company director. Removal for misconduct: if removed from an office of trust due to dishonesty-related misconduct. Criminal conviction: for serious offenses such as theft, fraud, or offenses related to company law violations. Termination of disqualification: 5 years after removal or completion of the sentence. Juristic person or partnership as secretary. Appointment: juristic person or partnership can be appointed, provided at least one employee/partner is permanently resident in South Africa and qualified. Disqualification: if they no longer meet the requirements, they must notify the company and are deemed to have resigned. Removal of company secretary. Board resolution: the board can resolve to remove the secretary. Right to statement: the secretary can request a statement to be included in the annual financial statements regarding the circumstances of their removal. _ 13.10 Registration of secretaries and auditors. Record maintenance: companies must maintain a record of their secretaries and auditors, including name and appointment date of each person. If a juristic person or firm is appointed, their registration details. Any changes to the appointed persons, with the date and nature of changes. _ 13.11 The role of an auditor in the future. Challenges and technological impact. Criticism: the role of auditors has faced severe criticism, leading to potential greater regulation. Blockchain technology such as blockchain, used in cryptocurrencies like Bitcoin, could transform how audits are conducted. Blockchain advantages: provides an unalterable audit trail that can be verified easily. Reduced human involvement: with blockchain, AI, and robots, fewer human auditors may be needed, leading to more efficient audits. IBM Maersk joint venture. Blockchain usage: IBM and Maersk are exploring blockchain technology for paperless trade, digitizing and automating trade documentation. Impact on auditors: Such innovations will likely transform auditing practices by reducing the need for traditional audit techniques and improving audit efficiency. Next page. Chapter 14. 14.1 Decriminalizing Company Law. Companies Act, 2008 aims to reduce criminal sanctions and instead offers private law remedies for gross mismanagement, abuse of power, and protection of stakeholders' rights. Directors and prescribed officers are made personally liable for losses, damages, and costs under various provisions, for example, Section 218(2). Criminal sanctions still apply for specific breaches, for example, S26 for failure to provide access to records, S214 for false financial statements. Non-criminal measures include compliance notices, administrative fines, court orders, delinquency/probation declarations, and personal liability for defaulting directors. 14.1.1 Abuse of position of director or prescribed officer. Section 162 allows for applications to declare a director delinquent or under probation. Section 165 gives shareholders the right to bring proceedings on behalf of a company if it's been prejudiced by controlling directors. Section 77 provides personal liability for directors and prescribed officers. Section 218 holds individuals liable for contravening the Act and causing losses. 14.1.2 Remedies available to shareholders to protect their own rights. Section 163 offers relief from oppressive or prejudicial conduct. Section 161 allows applications to protect rights of securities holders. Section 164 provides dissenting shareholders appraisal rights. 14.1.3 Abuse of the separate juristic personality of a company. Section 20 allows for the lifting of the corporate veil, imposing personal liability when the separate personality is abused. 14.2 Remedies against directors who have abused their position. Directors can face declarations of delinquency or probation under Section 162. Section 165 allows various stakeholders to institute actions on behalf of the company when directors abuse their position. 14.2.1 Application to declare director delinquent or under probation in terms of Section 162. Section 162 enables applications for a court to declare a director delinquent or place them under probation. The company, shareholder, director, employee representative, or the commission may bring the application. A delinquent director is disqualified from serving as a director. Probation allows limited service. Section 162 requires the commission to maintain a public register of delinquent or probationary directors. 14.2.1 Delinquency. Grounds for delinquency include acting while ineligible or disqualified, violating probation orders, acting with gross negligence, misconduct, or breach of trust, grossly abusing the position of director. The court can make an unconditional or conditional delinquency order. Unconditional delinquency can be for life. Conditional delinquency can last up to 7 years. Case study, Jaiwala v. Grancy Property Limited. Section 162(5)(c) of the Companies Act applied, where the conduct of directors included gross abuses of their position. The court ruled that directors acted in breach of their fiduciary duties, including failing to maintain accounting records and preparing accurate financial statements. A declaration of delinquency was made. Next page. 14.2.1 to probation. A court may place a director under probation under Section 162(7). Grounds for probation include acting in a manner materially inconsistent with director duties, failing to vote against a resolution when the company cannot satisfy the solvency and liquidity test as required by the Companies Act, 2008. Conditions for probation. The probation period is determined by the court, not exceeding 5 years. Court may impose conditions such as supervision by a mentor or limiting the director to serving in private companies or companies where they are the sole shareholder. 14.2.2 2.1.3 Conditions of order of delinquency or probation. Conditions that can be imposed on a delinquent or probationary director. Remedial education. Community service. After the probation or delinquency period, a director may apply to modify or set aside the order. 14.2 The derivative action, Section 165, Common Law. Initially, under Voss v. Harbottle, only a company could sue for wrongs done to it. Minority shareholders could not sue directors on behalf of the company. The court established the proper plaintiff rule: only the company could redress wrongs committed by directors. Derivative action. Exception to the proper plaintiff rule, allowing shareholders to bring legal action on behalf of the company if those in control are responsible for the wrong and are unlikely to act. A derivative action is initiated to protect the company's legal interests, a broader term than rights. TWK Agriculture Limited v. NCT Forestry Cooperative Limited emphasized that derivative actions are permitted where company controllers are wrongdoers. Problems with common law derivative action. Substantial legal costs for shareholders. Difficulties obtaining information needed for the case. Lack of clarity on what actions can be ratified by the majority, affecting the scope of the remedy. Statutory derivative action, Section 165. Who can initiate? Shareholders, directors, including prescribed officers, employee representatives, for example, trade unions, or anyone with court permission. The action is typically used against company controllers. Steps for statutory derivative action, Section 165(1). Demand. The person wishing to pursue the derivative action must serve a demand on the company to take legal action on its behalf. 2. Investigation. If the company does not set aside the demand, it must appoint an independent person to investigate and report on the matter. 3. Company response. The company must initiate or continue legal proceedings or refuse to comply within 60 business days. 4. Court application. If the company refuses to comply, the person may apply to court for permission to pursue the action. 5. Court approval. The court will grant permission if the company fails to meet statutory requirements, the person acts in good faith and the action is in the best interests of the company. But v. United Manganese of Kalahari, Proprietary, Limited Court discussed good faith and the applicant's responsibility to prove reasonable grounds for the action. Case study. Derivative action should not abuse court process. Maudson v. Greystones Enterprises, Proprietary, Limited. A director claimed another director's excessive credit card expenses were prejudicial to the company. Court emphasized the need for good faith in derivative actions. Personal animosity between the parties could indicate ulterior motives, but was not conclusive on its own. The court ruled in favor of the applicant, allowing the derivative action to proceed after proving good faith. Court rationale. Directors have a fiduciary duty to act in the best interests of the company. De Silva v. CH Chemicals, Proprietary, Limited confirmed that directors must exercise powers in good faith. In this case, the applicant demonstrated good faith by offering transparency regarding his own credit card use. Next. Page 14.3 Statutory remedies for shareholders. Relief from oppressive or prejudicial conduct, S163, dissenting shareholders' appraisal rights, S164, additional relief for securities holders, S161. 14.3.1 Relief from oppressive or prejudicial conduct, Section 163, background. Section 252 of the Companies Act, 1973, provided a remedy for minority shareholders facing oppression. Section 163 of the Companies Act, 2008 refines and broadens this remedy. Key refinements in Section 163, 2008 1. Broader scope. Applies to both shareholders and directors, unlike the 1973 Act which only allowed shareholders to approach the court. Directors, especially those appointed by minority shareholders, can now apply for relief if they face oppressive conduct or if their interests are unfairly disregarded. 2. Clearer and broader definition of oppressive conduct. The applicant must prove the conduct or omission is oppressive or unfairly prejudicial to their interests, or that the company's business is being conducted in such a way. A related person, who controls the company, may also be responsible for oppressive conduct. 3. New ground for relief, S-163(1)(c). Relief is now available if the powers of directors, prescribed officers, or related persons are exercised in a way that disregards the applicant's interests. 4. Court discretion. Under the 1973 Act, the court could intervene only if it was just and equitable. Section 163 allows the court to intervene, without needing to establish whether it's just and equitable, though this will likely still be considered. 5. Expanded relief options, S-163(2). Courts can now grant more specific orders, such as interim or final relief, for example, restraining the conduct, regulating the company's future conduct, amending the memorandum or shareholders' agreement, appointing or replacing directors, declaring someone delinquent, varying or setting aside transactions or compensating affected parties, rectifying company records. 6. Winding up alternatives. Section 163(2)(b) incorporates a provision from the Robson v. Wax Works, Proprietary, Limited case, which allows the appointment of a liquidator only if the company is insolvent. If the company is solvent, relief will focus on continuing the company's operations, including potentially buying out dissatisfied shareholders. 7. Expedited process, S-163(1) and S-163(2)(l). The remedy can be sought through application proceedings, requiring less time than oral evidence. If the case is contested, the court can direct a trial to resolve conflicting evidence. Case study, Robson v. Wax Works, Proprietary, Limited, Section 252, Companies Act, 1973, Facts. Applicant, a shareholder holding 30% of the company's issued share capital. The applicant, after acquiring shares, was excluded from decision-making processes. No proper shareholders' meetings were held. He applied for winding up on just and equitable grounds, under S-344H of the Companies Act, 1973. Court's ruling. The court ruled against automatic winding up, emphasizing that the interests of all shareholders must be considered. The majority shareholders offered to buy the applicant's shares at fair value, which was likely to be a better outcome than liquidation. The court found Section 252(1) of the Companies Act, 1973 provided an alternative remedy, and that winding up was unnecessary. The findings of the Robson case have been integrated into the Companies Act, 2008. These reforms aim to offer a more effective remedy for minority shareholders, allowing for better protection against oppressive conduct and clearer, more flexible relief options. Next page. Statutory remedies for shareholders. Relief from oppressive or prejudicial conduct, Section 163, Dissenting shareholders' appraisal rights, Section 164, Additional relief for securities holders, Section 161. 14.3.1 Relief from oppressive or prejudicial conduct, Section 163 Companies Act, 2008, Section 163, provides a statutory remedy to shareholders and directors to protect against oppressive conduct. Below are key refinements in comparison to the previous Companies Act, 1973, Section 252. Applicability to shareholders and directors. Section 163 extends the remedy to directors, not just shareholders, allowing directors appointed by minority shareholders to seek relief. Broader definition of oppressive conduct. The applicant must prove that an act or omission by the company or its controllers has resulted in oppressive or prejudicial conduct towards them. The oppressive conduct can arise from a single act or a series of actions. A related person includes anyone controlling the company, not necessarily the company itself. New grounds for relief. Section 163 1C introduces relief for situations where the powers of directors or related individuals are exercised in an oppressive or unfairly prejudicial manner. Court's broader discretion. The court's discretion has expanded, with more flexible intervention options than under Section 252 of the 1973 Act. The court does not need to establish that factors such as just and equitable conditions are met before intervening. Expanded range of relief. Section 163(2) provides a broader list of remedies, including restraining orders, amending company documents, appointing or removing directors, setting aside transactions or ordering compensation, winding up versus continuing the business. Section 163(2)(b) allows for the appointment of a liquidator only if the company is insolvent. If not insolvent, the court can order relief to continue the business, for example, by buying out a dissatisfied shareholder's shares. Expedited court procedures. Shareholders or directors can apply to the court via application proceedings, non-contentious, for quicker resolution, and if necessary, the court may order a full trial. Case study: dissatisfied shareholder under Section 252, Companies Act, 1973. Robson v. Waxworks, Proprietary, Limited. Facts: a minority shareholder, 30%, felt excluded from the company's decision-making. The company's internal mismanagement led to the shareholder seeking winding up under Section 344H of the Companies Act, 1973. Court's ruling: the court held that winding up was not the most appropriate remedy, because the majority shareholders were willing to buy out the dissatisfied shareholders' shares. The court concluded that relief under Section 252(3) was more just and equitable, emphasizing that winding up should not occur against the majority's wishes, when an alternative remedy, share buyout, existed. Case study: Court's broad powers under Section 163. Quadramain Investment Holding Limited v. Northern Cape Manganese Company, Proprietary, Limited. Facts: a minority shareholder, 49%, sought relief under Section 163 due to infighting among the majority shareholders, 51%, that jeopardized the company's operations. Court's ruling: the court affirmed that Section 163 allows the court to grant broad relief, stating that ongoing conduct, even if unresolved, can be subject to intervention. The court granted relief by declaring the authorized directors of the company, ensuring company governance during litigation. Case study: refusing to transfer shares. Visa Citrus, Proprietary, Limited v. Huda Hoop Citrus, Proprietary, Limited and others. Facts: the directors of a private company refused to approve a share transfer from one shareholder to another. The case considered the intersection of Section 163 and directors' fiduciary duties. Court's ruling: the court held that while directors must act in the best interests of the company, they must also exercise their powers in a manner that is not unfairly prejudicial to shareholders. In this case, the refusal was deemed fair, as the directors believed it was in the company's best interest, and their fiduciary duties were met. These case studies demonstrate how courts interpret and apply the broad discretionary powers granted under Section 163 to provide relief in situations of oppressive or prejudicial conduct, ensuring both the company's and shareholders' interests are balanced. Next. Page 14. 3. Dissenting shareholders' appraisal rights in terms of Section 164. Background. Companies Act, 1973, Section 102 allowed dissenting shareholders to apply to court for relief if the company varied the class rights of shares. Section 252 provided a remedy, typically involving the purchase of shares by the company. Companies Act, 2008, Section 164 introduces a new remedy for dissenting shareholders, known as appraisal rights, allowing shareholders to demand the fair value of their shares in certain circumstances, situations where Section 164 applies. 1. Variation of class rights, when a special resolution alters the rights or preferences of a class of shares in a materially adverse way to that class shareholders. 2. Disposal of assets, when a company considers disposing of all or a major part of its assets, Section 112. 3. Mergers or amalgamations, in cases of mergers or amalgamations, Section 113. 4. Schemes of arrangement, in cases of schemes of arrangement, Section 114. Section 164 does not apply to transactions under a business rescue plan. 5-step procedure for exercising appraisal rights. 1. Notification. The dissenting shareholder must notify the company in writing of their opposition, before the relevant resolution is voted on. 2. Demand for fair value. If the resolution is passed, the shareholder demands payment of the fair value of their shares. 3. Company determination of fair value. Initially, the company determines the fair value of the shares. 4. Court determination. If the shareholder rejects the company's offer, they may allow it to lapse or apply to the court for fair value determination. 5. Final decision. The shareholder can either surrender their shares for the court-determined price, or withdraw their demand if they find the court's decision unacceptable. Key points. Fair value. The fair value is determined immediately before the resolution was passed, potentially influenced by market conditions. Shareholder notice. The company must inform shareholders of their appraisal rights in the notice for the relevant meeting. Failure to vote against. Shareholders who fail to vote against the resolution lose their appraisal rights. Company response. After the resolution, the company must offer the fair value to dissenting shareholders and provide a statement showing how the value was determined. 30-day acceptance period. Shareholders must accept the offer within 30 business days, or the offer lapses. Court application. If the company fails to offer fair value, or the offer is inadequate, the shareholder can apply to the court. Court involvement. The court may appoint appraisers to assist in determining the fair value. The court's order gives shareholders the choice to either surrender shares or withdraw demands, reinstating their full rights, if they choose not to accept the value. Additional considerations. The company's payment to the shareholder does not qualify as an acquisition under Section 48, or as a distribution. If the company would become insolvent by paying the fair value, the company may apply to the court for an order varying its obligations. 14.3.3 Additional remedy to protect rights of securities holders, in terms of Section 161. Section 161 Overview. Section 161 provides a remedy for holders of issued securities to protect their rights in cases of harm by the company or its directors. Remedies available under Section 161. Declaratory order. A securities holder can apply to the court for a declaratory order regarding their rights under the Companies Act, 2008, the Company's Memorandum of Incorporation, MOI, any company rules, any applicable debt instrument. Appropriate orders. The court can grant an order to protect the securities holder's rights or rectify harm caused by the company or its directors. This section provides additional legal recourse for securities holders beyond the general protections of the Companies Act or common law. Next page. 14.4 Liability for abuse of separate juristic personality of company. Lifting or piercing the corporate veil. A court may lift the corporate veil to impose personal liability on shareholders or directors in cases of abuse of the company's separate juristic personality. This can occur under both common law and Section 29 of the Companies Act, 2008. Section 29 of the Companies Act, 2008, allows a court to declare that the company is not a juristic person if its formation, or any act by or on behalf of the company, constitutes an unconscionable abuse of its separate personality. The court may deem the company not a juristic person for rights, obligations or liabilities, and impose further orders to effect this declaration. Application. This can be declared upon application by an interested party or during proceedings involving the company. 14.5 Enforcement of rights, and ensuring compliance with the Act. Overview. The Companies Act, 2008 provides remedies, but these need enforcement mechanisms to be effective. The decriminalization of company law requires alternative enforcement measures. 4 basic alternatives for addressing complaints. 1. Alternative dispute resolution, ADR, aimed at resolving disputes informally. 2. Companies Tribunal can adjudicate on specific matters as allowed by the Act. 3. High Court, primary forum for resolving disputes. 4. Complaint to the Companies and Intellectual Property Commission, CIPC, can lead to a compliance notice. Enforcement body. The CIP typically enforces the Act, with some exceptions for the Takeover Regulation Panel. Encouraging ADR. The Act encourages the use of alternatives to court proceedings, as courts may penalize parties that skip ADR. Court action may only be pursued when other alternatives have been exhausted. 14.5.1 The Companies and Intellectual Property Commission, CIPC, CIP role. Replaces the Registrar of Companies under the Companies Act, 1973, and oversees company and intellectual property registrations. It operates as an independent state organ within public administration. Functions of CIP: monitor compliance with the Companies Act, investigate complaints related to contraventions of the Act, promote ADR for internal company disputes, issue compliance notices, promote reliable financial statements and advise on improving reporting standards, maintain and make public company registers, advise the minister on changes to company law. 14.5.1 2 Compliance notices. Issuing compliance notices. The CIP may issue a compliance notice if it believes someone has contravened the Companies Act or benefited from or been involved in such contravention. Review of compliance notices. A person who receives a compliance notice can apply to the company's tribunal for a review if dissatisfied. Contents of compliance notices. Details of the contravention. Steps required to rectify the issue. Penalties for non-compliance. Failure to comply. Failure to comply can lead to an administrative fine or prosecution under Section 214(3). Case study: compliance notice declared a nullity. In Pixoc v. CIP, the court found that the CIP had failed to afford the company a fair hearing before issuing the compliance notice. As no fair hearing occurred, the compliance notice was declared a nullity. Next page. 14.5.1.3 Investigation of complaints by the Commission. Role of the Commission. The Commission plays a central role in enforcing the Companies Act, 2008. Complaints regarding contraventions of the Act or violations of rights under the Act or a company's law or rules can be filed with the Commission. Filing a complaint. Complaints can be filed by any person alleging misconduct or infringement of rights. The Commission may also initiate complaints on its own or at the request of another regulatory authority. 3 basic responses to complaints. 1. Refusal to investigate, if the complaint is frivolous, vexatious, or lacks sufficient grounds. 2. ADR recommendation, suggesting the complainant resolve the issue through alternative dispute resolution, ADR. 3. Investigation, directing an inspector or investigator to investigate the complaint. Inspector and investigator. Inspector, appointed by the Commissioner, has authority to carry out investigations and issue summons. Investigator, appointed to assist in the investigation, but does not hold the same powers as an inspector. Summons and search warrants. The Commission can issue a summons for relevant persons to provide documents or testimony. A judge or magistrate may issue a search warrant if there are reasonable grounds to believe a contravention is occurring. Post-investigation actions. After receiving the report of an inspector or investigator, the Commission can refer the matter to the company's tribunal, propose a consent order for resolution, initiate court proceedings on behalf of the complainant, refer the matter to the National Prosecuting Authority or other regulatory bodies, issue a compliance notice, take no action and issue a notice of non-referral, advising the complainant of possible court action, publication of investigation reports. The Commission may choose to publish the report or deliver it to the complainant and the subject of the investigation. Time limitation for complaints. Complaints must be initiated within 3 years from the act or omission that caused the complaint, as per Section 219 of the Companies Act, 2008. Case study, Singh and others v. Companies and Intellectual Property Commission. Issue. The case involved a complaint filed by a person alleging that records with the Commission incorrectly reflected that he had resigned as a director, claiming his resignation was fraudulently procured. The complaint was opposed on the grounds that it was filed more than 3 years after the alleged fraudulent act. Court's ruling. The Supreme Court of Appeal ruled that Section 187(4) obligates the Commission to maintain accurate company records. If the records are incorrect, the act or omission is considered ongoing because the register continues to reflect fraudulent or inaccurate information. Therefore, the 3-year limitation period had not expired, as the inaccuracy in the register persisted. Next. Page 14.5.2 The Companies Tribunal. Establishment and functions. Based on provisions from the Competition Act regarding the Competition Tribunal, the 3 main tasks of the tribunal are: 1. Adjudicate applications made under the Companies Act, 2008. 2. Assist in resolving disputes through ADR, alternative dispute resolution, as outlined in the Act. 3. Perform any other function assigned by the Act. Jurisdiction and independence. The Companies Tribunal is a juristic person with jurisdiction throughout South Africa. It is independent and must perform its functions impartially. Composition. The tribunal consists of a chairperson and at least 10 members, full-time or part-time, appointed by the minister. Restrictions on membership include: persons disqualified from serving as directors of companies. Persons holding office in a political party or political body are disqualified. Adjudication. Section 156(b) allows any person to apply to the tribunal to address contraventions of the Act or enforce rights under the Act or a company's law or rules. Adjudication is expeditious and follows natural justice. Proceedings can be informal. Participants can be present in person or via a representative. Decisions must be issued with written reasons. Binding nature of decisions. A decision by the tribunal is binding on the Commission, subject to court review. No right of appeal for the Commission. If the tribunal favors the Commission, the other party can have the matter reconsidered by the court. 14.5.3 Voluntary resolution of disputes. ADR, alternative dispute resolution. Voluntary process allowing applicants to refer matters to the company's tribunal or an accredited entity for mediation, conciliation or arbitration. ADR includes: 1. Mediation. 2. Conciliation. 3. Arbitration. Mediation and conciliation involves a third party facilitating discussions between disputants. The mediator/conciliator cannot impose a solution. Any proposed solution must be accepted by both parties to be binding. Arbitration. Parties submit evidence and make submissions to an arbitrator. The arbitrator's award is final and binding. There is no appeal to the court, but the court can review the award on limited grounds, for example, procedural irregularity or excess jurisdiction. Voluntary participation. The use of ADR is voluntary, and both parties must agree to the process. If either party is not participating in good faith or there is no reasonable probability of resolution, the ADR process will fail, and a certificate stating this must be issued. Resolution and consent orders. If ADR leads to a resolution, it may be recorded as an order. If both parties consent, the order can be submitted to the court to be confirmed as a consent order under the court's rules. Next page. Chapter 15. 15.1 Introduction to the Winding Up and Deregistration of Companies under the Companies Act, 2008. Item 9 of Schedule 5 of the Companies Act, 2008. Companies Act, 1973 provisions on winding up continue to apply, particularly for insolvent companies, SS 337 to 426. Winding up of solvent companies is governed by both the 2008 and 1973 Acts, with certain 1973 sections not applicable to solvent companies. General provisions, SS 354 to 366, on winding up apply to both solvent and insolvent companies, including liquidator duties and powers, SS 367 to 411. Reason for continuation of 1973 Act provisions. New uniform insolvency legislation is proposed, after which provisions of the Companies Act, 1973 will cease to apply. Section 79(1) of the Companies Act, 2008. A solvent company may be dissolved through 1. Voluntary winding up by the company, S80. 2. Court-ordered winding up, S81. Solvency assessment considers the company's current financial position and future ability to pay debts, not immediately prior to dissolution. Section 82 of the Companies Act, 2008. The master must file a certificate of winding up when the company's affairs are fully wound up. The Companies and Intellectual Property Commission, CIPC, must record the dissolution and remove the company from the register. Solvent companies winding up. A special resolution can be adopted to wind up the company either voluntarily or by creditors. Notice and filing fees must be provided to SIP. Winding up by court, Companies Act, 1973. Section 344 of the 1973 Act provided for court winding up on grounds of inability to pay debts. This is not a ground for winding up a solvent company under the Companies Act, 2008. Insufficient grounds for winding up. Commercial insolvency, inability to pay debts in the normal course, may not be grounds for winding up unless proven under the Companies Act, 1973. Key court judgments. 1. Boschport Ondernemings, Proprietary, Limited v. Absa Bank Limited. Court held that factual solvency, assets exceeding liabilities, is not a ground to wind up a company. Commercial insolvency may still be relevant. 2. Knight v. Kameelhoek, Proprietary, Limited. Court ruled that a company is solvent even if illiquid, as long as assets exceed liabilities. 3. First Rand Bank Limited v. Lodi 5 Properties Investment CC. Emphasized that the Companies Act, 2008 does not eliminate the possibility of winding up on commercial insolvency grounds. Commercial insolvency still plays a role in winding up decisions. 4. Standard Bank of SA Limited via Bay Logistics CC. Commercial solvency is a prerequisite for applying provisions of Part G of the Companies Act, 2008. 5. Supreme Court of Appeal, Boschport. Reinforced that for winding up under the 2008 Act, a company must be commercially solvent. 6. Scania Finance Southern Africa, Proprietary, Limited v. Tommy G. Road Carrier CC. To invoke Chapter 14 of the Companies Act, 1973, insolvency must be proven first, or winding up must be initiated under S81. Next. Page X. 15.2 The winding up of solvent companies. Winding up provisions, governed primarily by the Companies Act, 2008, with some sections of the Companies Act, 1973 also applying, except for those listed as excluded in Item 9 of Schedule 5. Excluded sections, Companies Act, 1973. Section 343, Modes of Winding Up. Section 344, Circumstances for Court-Ordered Winding Up. Section 346, Application for Winding Up. Section 348, Commencement of Winding Up by Court. Section 349, Circumstances for Voluntary Winding Up. Section 350, Members' Voluntary Winding Up and Security. Section 351, Creditors' Voluntary Winding Up. Section 352, Commencement of Voluntary Winding Up. Section 353, Effect on Company Status and Directors. _ 15.2.1 Voluntary Winding Up of a Solvent Company initiated by the company. A company can wind up voluntarily if it passes a special resolution. Steps before resolution. Security for debt must provide satisfactory security to the master for paying off debts within 12 months of winding up. Consent to dispense security. The master may consent if a director's sworn statement that the company has no debts, a certificate from an auditor confirming no debts based on financial records. Liquidator's powers. Liquidator can exercise all powers under the Companies Act, 2008 and Companies Act, 1973 without court orders, subject to shareholder approval in a winding up by the company, creditor approval in a winding up by creditors. If the company is insolvent, winding up must comply with Section 363 of the Companies Act, 1973. Company during winding up stops carrying on business unless necessary for the winding up. Directors' powers cease, except when authorized by shareholders or creditors. _ 15.2 To winding up of a solvent company, by court order. Court order basis. As per Section 81, a court may order the winding up of a solvent company if special resolution, the company resolves to wind up by court order. Business rescue. A practitioner applies during business rescue if there is no prospect of rescuing the company. Creditor's application. Creditors may apply if business rescue ends without success or if it's just and equitable. Deadlock. Directors are deadlocked, and shareholders cannot resolve it. Shareholders are deadlocked in voting power, and successors to directors have not been elected for at least 2 AGM cycles. Fraud or misapplication. If there are allegations of fraud, illegal actions or misapplication of assets, a shareholder or regulatory body can apply. Court's discretion. The court has discretion to grant a winding up order, and it applies judiciously, typically reluctant to interfere with the company's internal affairs. _ Case study, interpretation of Section 81(1)(d), case, Budge N&O v Midnight Storm Investments 256, Proprietary, Limited, 256 2016, issue interpretation of the just and equitable ground, under Section 81(1)(d). Court's decision. The court rejected a restrictive interpretation of the phrase, just and equitable in Section 81(1)(d). 3. The court held that the justum generis rule, limiting interpretation to similar circumstances, does not apply to this provision. Deadlock situations, directors or shareholders, are explicitly covered in Section 81(1)(d) and Section 81(1)(d). 2. Just and equitable is broad, and Section 81(1)(d) 3 should cover all grounds for winding up not related to deadlock. Legal basis. The court reaffirmed that the legal basis for winding up under Section 81(1)(d) 3 aligns with the principles in the Old Companies Act. Next. Page 15.2 The winding up of solvent companies. Legislation involved. Primarily governed by Companies Act, 2008. Companies Act, 1973 sections apply unless excluded. Refer to Table 15.1 for excluded sections. Key excluded sections, Companies Act, 1973. Sections 343, 344, 346, 348 to 353, relating to court-ordered winding up and other specific processes. _ 15.2.1 Voluntary winding up of a solvent company initiated by the company. Special resolution required for voluntary winding up by the company. Before filing the resolution and notice, the company must arrange for security, master's approval, for the company's debts to be settled within 12 months, or consent of master to dispense with security if director's sworn statement confirming no debts, auditor's certificate confirming no debts. Section 85. Liquidator in voluntary winding up can exercise powers under the Companies Acts without a court order unless directed by shareholders or creditors. Court's involvement in insolvent winding up. Court may set aside voluntary winding up if the company is insolvent upon creditor's application. Section 88. The company remains a juristic person, but must stop carrying on business except for winding up purposes. Directors' powers cease except as authorized by liquidator/shareholders, if winding up by creditors or company. _ 15.2 To winding up of a solvent company, by court order. Grounds for court order, Section 81. Special resolution. Company resolves by special resolution to be wound up by the court. Business rescue. If business rescue fails, the practitioner may apply for liquidation. Creditor's application. Creditors can apply for winding up if business rescue failed, or if just and equitable. Deadlock in management. If directors are deadlocked and cannot resolve, it may be just and equitable to wind up the company. Fraud or misconduct. If the company or its directors are engaged in fraudulent or illegal activities. Commission/panel application. If company fails to comply with the compliance notice issued by the commission or panel. Discretion of the court. Court's decision is discretionary, irrespective of the grounds for winding up. Court applies principles judiciously, considering reluctance to interfere in internal affairs of the company. _ Case study, interpretation of Section 81(1)(d), Budge NNOV Midnight Storm Investments 256, Proprietary, Limited. Issue: whether the just and equitable ground for winding up in Section 81(1)(d)(3) is restricted to the deadlock categories in Sections 81(1)(d)(i) and (2). Court's ruling. The court ruled that the just and equitable ground under 81(1)(d)(3) is not e justum generis, not limited, to the deadlock grounds under 81(1)(d)(i) and (2). The justum generis rule, restricting to similar categories, is inapplicable in this context. The just and equitable ground is broader and includes other cases of deadlock not covered in I and 2. _ Case study, complete deadlock versus deadlock principle. Cilliers No v. Doan and C. Proprietary, Limited. Distinction: the court differentiated complete deadlock, total division in decision-making, from deadlock in principle, breakdown in trust or confidence akin to a partnership. Ruling: Sections 81(1)(d)(i) and 2 apply to complete deadlock, while 81(1)(d)(3) applies to deadlock in the principal sense. Under Katz Investments 92. The Supreme Court of Appeal affirmed that 81(1)(d)(3) extends to other forms of deadlock beyond the examples given in 81(1)(d)(i) and 2. The court noted that the use of otherwise means the just and equitable ground can include broader deadlock scenarios. _ Case study, partnership principle and just and equitable winding up. Muller v. Lily Valley, Proprietary, Limited. Issue: whether the breakdown of shareholder relations justifies winding up a private company analogously to the dissolution of a partnership. Court's conclusion: the breakdown must be due to the other shareholders' conduct, not the applicant's. The applicant must show that the relationship's breakdown creates a justifiable lack of confidence in the company's management. Principal shareholders, even minority ones, must abide by the decisions of the prescribed majority unless the breakdown is severe. The applicant failed to meet these criteria, and the application for winding up was denied. Under Katz Investment Partnership analogy, the court likened the company relationship to a partnership, considering the breakdown of trust and confidence akin to partnership dissolution. In cases of complete breakdown in a small company, similar to a partnership, just and equitable principles may justify winding up. _ Guiding principles for winding up of a solvent company. Principles from case law. Examples of grounds for winding up under just and equitable. Disappearance of the company's substratum, core purpose. Resignation of all directors, inability to appoint new ones. Serious criminal offenses. Erosion of the company's income base. Deadlock in management. Minority shareholder oppression. Partnership principle breakdown. Imminent financial crisis. Court's discretion. Minority shareholder. Winding up by a minority shareholder is rare, and typically only occurs where there are no alternative remedies. The court requires alternative remedies to be exhausted before granting a winding up order. Leave of court. Shareholders seeking winding up must first seek leave of the court. Restrictions. A shareholder must have held shares for at least 6 months prior to application. Next X. Page. Case study, complete deadlock versus deadlock principle. Cilliers No v. Doohan and C. Proprietary, Limited. The court distinguished between two forms of deadlock. Complete deadlock, directors and shareholders are completely divided and cannot make decisions necessary for the company. Deadlock principle, a breakdown in trust and confidence akin to a partnership relationship. Sections 81(1)(d) and 2 apply to absolute deadlock, while Section 81(1)(d) 3 applies to the wider deadlock principle, which encompasses situations beyond complete deadlock. Thundercats Investments. Supreme Court of Appeal agreed that Section 81(1)(d) 3 is not restricted by the earlier subsections I and 2. The use of otherwise in subsection 3 suggests it extends the grounds of winding up, even in cases where shareholders have not been unable to elect successors within the stipulated period. Case study, applying the partnership principle in the context of winding up private companies. Muller v. Lily Valley, Proprietary, Limited. The just and equitable ground for winding up is based on fairness between competing interests. The applicant argued that a breakdown between shareholders, analogous to a partnership dissolution, justifies winding up. 2 hurdles for the applicant. 1. Demonstrating the breakdown was due to the other shareholder's conduct, not his own. 2. Showing that even if the conduct was contrary to his wishes, the majority decision still holds legally. Court's conclusion, the applicant failed to show misconduct by the other shareholders, justifiable resignation as an employee/director, a significant breakdown of the relationship justifying a lack of confidence, that his position outweighed the prejudices to others. Additional requirement, the court must be satisfied that all alternative remedies have been explored and failed before granting winding up. Thundercats Investment. The court recognized a partnership-like relationship between the parties and granted liquidation due to the irretrievable breakdown of trust. APCO Africa Incorporated v. APCO Worldwide, Proprietary, Limited. The deadlock principle is based on an analogy with partnerships in small, closely held companies. Case study, guiding principles for winding up a solvent company. The Duplessis v. Bonnox Proprietary Limited, and another case outlined principles guiding when winding up is appropriate. Examples for winding up. Company's substratum has disappeared. Entire board resignation with no new board appointment. Serious criminal offense by the company, for example fraud, racketeering. The company is unable to make a profit for more than 6 months. Complete deadlock in company management. Minority shareholder oppression with no alternative remedy. A situation analogous to the dissolution of partnerships. Imminent financial turmoil. Exceptional circumstances. Winding up at the request of a minority shareholder is exceptional, particularly when no other remedies are available. The court must first grant leave for such an application, and the shareholder must have held shares for at least 6 months. Next page. 15.3 The winding up of insolvent companies. The winding up of insolvent companies is still governed by the Companies Act, 1973, under the provisions of Chapter 14, Sections 337 to 426. Below is a summary of the sections relevant to the winding up process, including the powers and duties of liquidators. Table 15.2, Sections of the Companies Act, 1973 applicable to winding up. Heading Sections Subject Matter. General 337 to 343 General Provisions relating to winding up of companies. Winding up by the court 344 to 348 includes provisions on when and how a company may be wound up by the court. Winding up by court 344 circumstances in which a company may be wound up by the court. 345 when a company is deemed unable to pay its debts. 346 application for winding up of a company. 346 a service of winding up order. 347 power of court in hearing application. 348 commencement of winding up by court. Voluntary winding up 349 to 353 provisions for voluntary winding up, either by members or creditors. Voluntary winding up 349 circumstances under which a company may be wound up voluntarily. 350 members voluntary winding up and security. 351 creditors voluntary winding up. 352 commencement of voluntary winding up. 353 effect of voluntary winding up on the status of the company and on directors. General provisions affecting all windings up 354 to 366 provisions that apply to all forms of winding up, court and voluntary. General provisions 354 court may stay or set aside winding up. 355 notice to creditors or members in review by court in winding up, and no reopening of confirmed accounts. 356 notice of winding up of company. 357 notice of winding up to certain officials and their duties. 358 stay of legal proceedings before winding up order granted. General provisions 359 legal proceedings suspended and attachments void. 360 inspection of records of company being wound up. 361 custody of or control over and vesting of property of company. 362 court may order directors, officers, and others to deliver property to liquidator or to pay into bank. 363 directors and others to submit statement of affairs. 363 a change of address by directors and secretaries and certain former directors and secretaries. 364 master to summon first meetings of creditors and members and purpose thereof. 365 offences in securing nomination as liquidator and restriction on voting at meetings. 366 claims and proof of claims. Liquidators 367 to 385 provisions regarding the appointment, powers and duties of liquidators. Appointment of liquidator 367 Appointment of liquidator. 368 Appointment of provisional liquidator. 369 Determination of person to be appointed liquidator. 370 Master may decline to appoint nominated person as liquidator. 371 Remedy of aggrieved persons. 372 persons disqualified from appointment as liquidator. 373 persons disqualified by court from being appointed or acting as liquidators. 374 Master may appoint co-liquidator at any time. 375 Appointment, commencement of office, and validity of acts of liquidator. 376 Title of liquidator. 377 Filling of vacancies. 378 Leave of absence or resignation of liquidator. 379 Removal of liquidator by master and by the court. 380 Notice of removal of liquidator. 381 Control of master over liquidators. 382 Plurality of liquidators, liability, and disagreement. 383 Cost and reduction of security by liquidator. 384 Remuneration of liquidator. 385 Certificate of completion of duties by liquidator and cancellation of security. Powers of liquidators 386 to 390 The powers granted to liquidators during the winding up process. Duties of liquidators 391 to 411 The duties imposed on liquidators during the winding up process. Provisions as to meetings in winding up 412 to 416 Provisions governing meetings during winding up. Examination of persons in winding up 417 to 418 Provisions for examining individuals related to the company during the winding up process. Dissolution of companies and other bodies 419 to 422 The final steps in the dissolution process for companies and other corporate bodies. Personal liability of delinquent directors 423 to 426 Provisions holding delinquent directors and others personally liable for certain acts or offences. Next. Page 15.4 The deregistration of companies. Deregistration refers to the process of removing a company from the official companies register, marking the end of its existence as a legal entity. Below is an outline of the relevant provisions and procedures for deregistration. 15.4.1 Procedures for deregistration of a company. Section 83(1). A company is dissolved when its name is removed from the company's register. Section 83(2). The removal of a company's name does not affect the liability of former directors or shareholders for acts prior to deregistration. Section 82. Deregistration procedures. 1. Winding up certificate. The master must file a certificate of winding up once a company's affairs are concluded. Upon this, the Commission must record the company's dissolution, remove the company from the company's register. 2. Deregistration on transfer of registration. If the company has transferred its registration to a foreign jurisdiction under Section 82(5), it may be deregistered. 3. Failure to file annual returns. If a company fails to file annual returns for 2 consecutive years and does not provide satisfactory reasons, it may be deregistered. 4. Inactive or no assets. The Commission may also remove a company from the register if the company has been inactive for at least 7 years, and there is no reason for its continued existence. It has ceased to carry on business, and has no assets or insufficient assets for liquidation. Case studies on deregistration and its consequences. Luckitzo Transport and Construction CCV Absa Bank Limited. Upon deregistration, a company's assets become bona vacantia, ownerless property, automatically passing to the state. A company ceases to exist legally, and its assets cannot be managed or liquidated by a liquidator. Valley View Homeowners Association case differentiates between deregistration, removal from the register, and dissolution, formal end of corporate existence. While both lead to the cessation of corporate existence, deregistration is not a liquidation but a cessation of activity. 15.4. To reinstatement and application to declare dissolution void. Section 82(4) allows interested parties to apply for the reinstatement of a deregistered company. The Commission may reinstate the company after it files outstanding annual returns and pays required fees. ZNK Investment CC case. The Supreme Court of Appeal held that reinstating a company's registration has retrospective effects, revesting its property and validating its activities during the deregistration period. Section 83(4) provides that after a company is dissolved, a liquidator or interested party may apply to a court to declare the dissolution void. If successful, the company's legal status is restored, and proceedings can continue as if it had not been dissolved. Case studies on reinstatement. Valley View Homeowners Association v. Universal Pulse Trading 27, Proprietary, Limited. The court ruled that a company must be reinstated before a winding up order can be made. Deregistration means that the company ceases to exist as a legal entity until reinstated. Absa Bank Limited v. Companies and Intellectual Property Commission of South Africa. The court clarified that Section 83(4) applies to all cases of deregistration, including those due to failure to file annual returns, and allows a court to issue any order deemed just and equitable. An interested party can apply either to the Commission for reinstatement or to the court to declare dissolution void. Key point summary. Deregistration removes a company from the register and marks the end of its legal existence, transferring all assets to the state as bona vacantia. Reinstatement can be done through the Commission under Section 82(4) or through the court under Section 83(4), depending on the situation. Legal cases have clarified the process and legal consequences of deregistration, including the automatic transfer of assets to the state and the legal standing of the company thereafter. Next. Page 15.4.3 Legal effect of a company's actions when it has been deregistered. This section deals with the legal consequences of a company's actions during the period of its deregistration, including the distinction between cancellation and reinstatement of a company's deregistration. Fintech, Proprietary, Limited v. Awake Solutions, Proprietary, Limited case. Background. The company was deregistered under the Companies Act, 1973, for failing to file annual returns. In April 2012, the deregistration was cancelled by the Commission under the Companies Act, 2008. The key legal issue was whether the actions taken by or against the company during the period of deregistration were valid. Deregistration versus cancellation. Deregistration, according to the court, deregistration under the Companies Act, 1973, ends the company's existence. Cancellation, the court distinguished cancellation of deregistration from reinstatement. Cancellation removes the entire deregistration process, effectively treating it as if it never occurred, while reinstatement restores the company to its status prior to deregistration. Court ruling. The court found that the cancellation of deregistration meant that the company had always remained a corporate entity. Acts done by or against the company during the period of deregistration were valid and remained in full force. Even if viewed as reinstatement under the Companies Act, 2008, the court held that reinstatement does not necessarily imply retroactive validation of actions taken during deregistration unless expressly provided for. Legal consequences and subsequent appeal. In the appeal, the Supreme Court of Appeal upheld the lower court's judgment, but provided different reasoning. It concluded that Awake Solutions, Proprietary, Limited had likely been wound up, and the court affirmed that once a company is placed into liquidation, its existence is retained until the liquidation process is completed. Consequently, deregistration of a company in liquidation due to non-filing of returns was deemed legally invalid. Cancellation of deregistration. The court noted that the cancellation of deregistration meant there was nothing left for the court to declare invalid. This judgment emphasized that a company in liquidation cannot be deregistered administratively, and such deregistration is legally void and can be set aside through judicial review. Practical implications of the judgment. Retrospective effect of reinstatement. The Supreme Court of Appeal's judgment suggests that the reinstatement of a company's registration results in automatic retrospective validation of its corporate activities during the deregistration period. This includes actions such as winding up proceedings, which may have been initiated during the period the company was deregistered. Key point summary. Deregistration and cancellation. Deregistration ends a company's existence, but cancellation of the deregistration process treats the company's status as if it never ceased to exist. Reinstatement is seen as returning a company to its pre-deregistration status, but without the express provision for retroactive effects. Deregistration of companies in liquidation. A company in liquidation cannot be deregistered administratively for failing to file annual returns. If deregistered, such deregistration is legally invalid and can be overturned upon review. Retrospective validation. Reinstatement automatically validates a company's actions taken during the period of deregistration, including legal proceedings like winding up actions. Next page. Chapter 16, Close Corporations. 16.1 The nature of a close corporation and its members. Close Corporations Act. The Act provides for the creation of close corporations, designed for small businesses with simple, flexible, and deregulated structures, offers limited liability and perpetual succession. Founding Statement, Form CK1, establishes the close corporation, outlining details like its name, financial year, members, accounting officer, and principal business. Juristic person. A close corporation is a separate legal entity with the capacity of a natural person, meaning the ultra vires doctrine doesn't apply. Transactions beyond the stated business in the founding statement are still valid. Members. No shareholders, only members, who can be individuals, natural persons. A maximum of 10 members, indicating a focus on small businesses and the close-knit relationships similar to partnerships. Membership. Only natural persons can be members, no juristic persons allowed. Exceptions allow trustees of trusts to be members under certain conditions. Business restrictions. No restrictions on the number of employees, assets, turnover, or business type, meaning a close corporation can continue to exist regardless of its size. 16.2 Close Corporations and the Companies Act, 2008. Implications of the Companies Act, 2008. No new close corporations. After the 1st of May 2011, no new close corporations can be created, nor can companies be converted into close corporations. Existing close corporations, those in existence before the 1st of May 2011, may continue indefinitely, but new formations or conversions are prohibited. Key provisions. Capital maintenance abandoned. Both acts abandon capital maintenance in favor of solvency and liquidity tests before transactions like dividend declarations or share buybacks. Conversion to companies. Schedule 2 outlines how existing close corporations can be converted to companies. Schedule 3 amends the Close Corporations Act, including new requirements for financial reporting and compliance with IFRS, auditing, and business rescue provisions. Conversion procedure. Close corporations can convert into companies by submitting consent statement, approval from members holding at least 75% of the interest. Memorandum of Incorporation, MOI, must meet Companies Act, 2008 standards. Filing fee. Post-conversion effects. Continuity. The juristic personality of the close corporation continues as a company. Liabilities. Any member's liability for the corporation's debts remains after conversion. Legal proceedings. Ongoing legal actions continue under the converted company. Next page. 16.3 Contributions by members and nature of members' interests. Contributions on formation. Members must contribute money, assets, or services at the formation of a close corporation. Details of contributions must be included in the founding statement. Contributions may be increased or decreased with agreement, and such changes must be reflected in an amended founding statement. Nature of members' interest. Each member has a single interest expressed as a percentage. The total of all members' interests must equal 100%. A member's interest cannot be held jointly, to prevent evading the 10-member limit. Membership is recognized when the founding statement is registered. A certificate of members' interest is issued, stating the member's percentage. Cessation of membership. Membership ends upon the disposal of the member's interest, reflected in an amended founding statement. A court order can also terminate membership under S36 of the Close Corporations Act. Legal nature of members' interest. The interest is movable property, transferable according to the Act. The member's interest is incorporeal, and represents a personal right against the corporation. Voting rights and profit distribution. Voting rights and participation in profit distributions are in proportion to a member's interest, unless specified otherwise in an association agreement. 16.4 Acquisition and disposal of a member's interest. Acquiring member's interest. New members acquire interests either from an existing member or by contributing money or assets. Percentage of the new member's interest is agreed between them and existing members, reducing the latter's interests proportionately. Disposal of members' interest. Disposition must adhere to the association agreement or be approved by all members. The corporation can buy the member's interest or the interest can be sold to a qualified outsider, insolvent or deceased member. In case of insolvency, the procedure for the disposal of the interest is outlined in S34(1) of the Act. In case of death, the member's interest can be transferred to a legatee or heir with consent from other members, or sold with specific restrictions under S35(b). Case study Lavano Snow v. Oates. The court applied S35 and S34(2) in determining how a deceased member's interest should be sold. The remaining members' failure to exercise their preemptive right allowed the sale to proceed. 16.5 The duties members owe to the close corporation. Fiduciary duty. Members owe a fiduciary duty to the corporation, including acting honestly, in good faith, and in the corporation's best interests. They must avoid conflicts of interest, not exceed their powers, and disclose material interests in contracts. A breach results in personal liability for any loss suffered or benefit obtained by the member. Written approval from all members can exempt certain actions from being breaches. Duty of care and skill. Members are liable for breach of duty of care only if it results in a loss to the corporation. The standard is based on the member's knowledge and experience, introducing a subjective element. Liability can be avoided if all members approve the action, with full knowledge of the facts. Legal proceedings for breach of duty. To initiate court proceedings, members need at least 51% support from the corporation's interests. Section 50 allows other members to bring proceedings in the name of the corporation in certain circumstances, including breaches of fiduciary duty or duty of care. Proceedings are subject to court approval and cannot be settled or withdrawn without the court's consent. Case study Fiduciary Duties, Gainey v. Portion 117 Calcuville Properties C.C. The court affirmed that a close corporation requires a relationship of trust and confidence, similar to partnerships. The court held that members must act reasonably, honestly and cooperatively. If these duties are breached, the corporation can seek winding up. These summaries focus on the key sections and legal implications of members' contributions, their rights and duties, and the disposal of their interests, including related case law and statutory provisions. Next page. 16.6 Cessation of membership by order of court. The Close Corporations Act provides two primary remedies for members against other members. 1. Termination of membership via a court order under Section 36. 2. Assistance for unfairly prejudicial conduct by a member under Section 49. Court orders may result in amending or adding to the founding statement or association agreement of the corporation. In cases of financial difficulties or deadlock, the court may resort to winding up the corporation, instead of granting relief under Sections 36 or 49. 16.6.1 Section 36, Order of Court. Section 36 allows a member to apply for a court order to terminate any member's membership, including their own. Key uses: ending member deadlocks. Burden of proof: the applicant must establish one or more grounds for membership termination. Permanent inability to perform their part in the business. Conduct likely to prejudicially affect business operations. Conduct making it impossible for others to associate with the member in business. Circumstances that make it just and equitable for the member to cease membership. The termination affects the member's interest in the corporation, and the applicant must present evidence for the court to determine how the member's interest should be acquired, by the corporation or other members. 16.6. To Section 49, Unfairly Prejudicial Conduct. Section 49 provides relief for members facing unfair prejudice from acts/omissions by the corporation or other members. The member seeking relief must prove that unfairly prejudicial conduct occurred. Court's role: the court will intervene if the conduct is unfair, and would be just and equitable to do so. Possible court orders: regulate future conduct of the corporation. Facilitate the purchase of a member's interest by the corporation or other members. The court will not order the acquisition of a member's interest if the corporation is unable to pay major creditors. Courts have interpreted regulating the future conduct broadly, extending beyond daily operations, for example, selling a major asset to address financial difficulties. Case study: winding up on just and equitable grounds. Case: Kanakia v. Ritschulf 1004 CCTA Passage to India. Facts: applicant and second respondent, equal members of a restaurant business, experienced a complete breakdown in their relationship. Applicant sought liquidation under Section 68D due to deadlock between the members. The second respondent countered with an application under Sections 36 and 49 to terminate the applicant's membership and acquire their interest, or for the second respondent, purchase the applicant's interest. Court's decision: mere deadlock does not automatically justify liquidation under Section 68D. Courts must assess all circumstances and decide if liquidation is just and equitable. It is not just and equitable to wind up the corporation solely based on deadlock. Court considered alternatives, finding that termination of the applicant's membership under Section 36 would have severe consequences. Burden of proof: the member applying for relief under Section 36 must prove entitlement to the requested order. Court refused to order termination of membership or transfer of interests due to lack of audited financial statements, leaving the financial position unclear. Conclusion: the court ordered the winding up of the corporation instead, citing financial difficulties and deadlock. The counter-application was dismissed as it was not just and equitable to proceed with the membership termination due to the applicant's contingent liabilities towards creditors. Next. Page 16.7 Acquisition of members' interests by corporation and financial assistance. Solvency and liquidity test. Special requirements apply when a closed corporation acquires a member's interest to protect creditors, similar to share buybacks in companies. Conditions for acquisition: the corporation must have at least one other member at the time of acquisition. The acquired interest must be redistributed among remaining members in proportion to their existing interests, maintaining 100% ownership. Payment for the interest requires written consent of all members, compliance with solvency and liquidity requirements. Solvency and liquidity requirements: after payment, the corporation's assets, fairly valued, must exceed its liabilities. The corporation must be able to pay debts as they become due. The payment must not make the corporation unable to meet its debts in the ordinary course of business. Financial assistance: the corporation may provide financial assistance to another person to acquire a member's interest. Requirements: written consent from all members, compliance with solvency and liquidity requirements. Financial assistance includes direct or indirect help in connection with acquiring a member's interest, such as repaying a loan to reduce the purchaser's cost. 16.8 Internal relations and association agreements. Management and capital providers. The Closed Corporations Act treats all members equally, with no formal distinction between capital providers and managers. No obligation for association agreements. Members are not required to have an association agreement, though it is highly recommended for corporations with multiple members. An association agreement is optional but should be used to regulate internal relations to avoid conflicts. Default rules between members. Participation. Every member has the right to participate in the business and management. Major decisions. Written consent from members holding at least 75% of interests is needed for changes in the corporation's principal business, disposal of the whole or a significant part of the business/assets, acquisition/disposal of immovable property. Decision-making. Majority vote determines matters related to the business. Voting. Each member has votes corresponding to their interest in the corporation. Indemnification. The corporation must indemnify members for expenses incurred in the business proper conduct. Proportional payments. Payments to members under Section 51(1) are made in proportion to their respective interests. Association agreements. Definition: an agreement entered into by members under Section 44 that regulates internal relations and any other matters consistent with the Act. The agreement must be in writing and signed by all members. New members are bound by the agreement as though they signed it. Any amendment to the agreement requires written consent from all members. Inspection. The agreement must be kept at the corporation's registered office, available for inspection by members but not by non-members unless allowed by the Act. No automatic knowledge. Third parties dealing with the corporation are not deemed to have constructive knowledge of the agreement. Other agreements. Members may enter into other agreements, express or implied, not inconsistent with the association agreement. These agreements cease to be valid when a party leaves the corporation. Binding nature. The association agreement binds both the corporation and its members in their respective capacities. Matters not alterable by association agreements. Insolvent member's interest. The manner of disposing of an insolvent member's interest cannot be altered by an association agreement. Disqualified members. Section 47 disqualifies certain members from management, and this cannot be overridden by the association agreement. Right to call a meeting. Every member has the unalterable right to call a meeting. Variable rules. Members are entitled to participate in the business and management unless disqualified by the Act. Decisions are made by majority vote. Payments to members are made in proportion to their membership interest. Next page. 16.9 Power of members to contract on behalf of close corporation. Section 54 of the Act. Every member of a close corporation acts as an agent of the corporation in dealings with non-members. A member can bind the corporation, even if the act is unrelated to the corporation's business, unless the third party is aware the member lacks authority. Case study: J&K Timbers, Proprietary, Limited v. G.L.&S Furniture Enterprises, C.C. Court ruled that a member, even without express or implied authority, can bind the corporation unless the third party knows the member lacks such authority. Ultra vires doctrine and doctrine of constructive notice do not apply in dealings with third parties. If a member appoints an outsider, for example, attorney, to act on behalf of the corporation, the outsider has authority to conclude contracts, even without other members' consent. 16.10 Payments by corporation to members. Section 51 of the Close Corporations Act. Payments by a corporation to members, solely due to membership, require the corporation to meet solvency and liquidity requirements after the payment. Payments include distribution or repayment of contributions, excludes payments for creditor or employee status. Repayment of contributions requires lodging an amended founding statement. Distribution of income requires approval by a resolution of members holding at least 51% of the interests. If solvency and liquidity requirements are violated, the member must repay the payment. On winding up, the onus of proving solvency and liquidity shifts to the member. 16.11 Prohibition on loans to and security on behalf of members. Section 52 of the Act. The corporation cannot make a loan or provide security to its members, another corporation with over 50% shared interest from its members, a company controlled by its members. Loans or security made without written consent from all members are invalid and cannot be ratified. Case study: Honeycomb v. Builders Market Klakstorp, Proprietary, Limited. Court confirmed that S52 protects non-consenting members by requiring written consent for loans or security. If a corporation has only one member, the provision may lead to an absurd result if interpreted literally. The court found that a sole member's consent to sign suretyship was sufficient, disregarding the need for written consent from other members, as there were none. The suretyship was valid despite the strict interpretation of the section. Next page. 16.12 Accounting Officer, Accounting Records, and Annual Financial Statements. Annual financial statements must include statement of financial position, Income Statement. Accounting Officer's Report. According to S58-2B and S58-2C, financial statements should meet Generally Accepted Accounting Practice (GAP) and specific disclosures. The following are expected in the annual financial statements: Statement of Financial Position and Related Notes, Income Statement and Related Notes, Statement of Changes in Equity, Cash Flow Statement, Accounting Officer's Report, or Audit if required, Statement of Members' Net Investment and Movements, Schedule of Transactions with Members. Approval. Annual financial statements must be approved by members holding at least 51% of the corporation's interest. Audit Requirements. Companies Act, 2008. If a closed corporation falls under specific categories, its financial statements must be audited. Case Study. Maxillari v. Help You Build Project Management CC. Court ruled that by signing financial statements, members accepted both the financial accounts and the accounting officer's report, including the subordination of loan accounts. The subordination agreement did not need to be separately written out, as it was implied by the members signing. Fair value of assets. Sections of the Act, 39, 40, 51, 62, emphasize that assets should be fairly valued, not at historical cost, and that liabilities must not exceed assets after certain payments or financial assistance. Members may be liable to repay payments made contrary to solvency and liquidity requirements. Accounting Officer's Role. Ensures financial statements align with accounting records. Reviews accounting policies. Reports to the Commission if financial statements incorrectly indicate that assets exceed liabilities. Financial statements show assets exceeding liabilities when they do not. Accounting Officer's Report. Example. Responsibilities. Confirm financial statements align with accounting records. Audit. No audit required unless specified. Duties. Ensures appropriateness of accounting policies and reports if any discrepancies in financial statements are found. Key sections to note. Section 39. Payment for members' interests, only if assets exceed liabilities. Section 40. Financial assistance provided only if assets exceed liabilities. Section 51. Payments to members contingent on assets exceeding liabilities. Section 62. Accounting Officer's duty to report incorrect financial indications. Next. Page 16.1 Duties of the Corporation, Members and Accounting Officer in relation to accounting records and financial statements. Table 16.1 Duties of the Corporation. Section of the Closed Corporations Act. Duty of the corporation. Liability for non-compliance. Section 56 Keep necessary accounting records, including accounts, deeds, writings, and prescribed documents. Corporation and any member who failed will be guilty of an offense. Section 57 Fix a year-end for the corporation. N. Section 59 Appoint an accounting officer. Appoint a new officer within 28 days if there is a vacancy. Notify the officer if they are removed. N. Table 16.2 Duties of Members. Section of the Closed Corporations Act. Duty of members. Liability for non-compliance. Section 58 Ensure annual financial statements are made within 6 months of year-end. Members holding at least 51% must approve and sign the annual financial statements. Members who fail to comply will be guilty of an offense. Table 16.3 Duties of the Accounting Officer. Section of the Closed Corporations Act. Duty. Section 59.5 Inform every member in writing upon resignation or removal. Send a copy of the resignation/removal letter to the corporation's registered office. Inform the Commission of certain information. Section 59.5b Inform the Commission and every member if they believe they have been removed for improper reasons. Section 60 Ensure proper qualification to act as an accounting officer. Section 62 Determine if financial statements align with accounting records and report to the corporation. Review the appropriateness of the accounting policies used in preparing the financial statements. Report on the above matters to the corporation. Describe any contraventions of the Close Corporations Act in their report. Disclose if they are a member or employee of the corporation, or if the firm is connected to the corporation. Report to the Commission if 1. They believe the corporation is not carrying on business and has no intention of resuming operations. 2. Changes in particulars of the founding statement have not been registered. 3. The financial statements indicate that liabilities exceed assets. 4. They find that the financial statements incorrectly indicate assets exceed liabilities or have reason to believe this. Next. Page 16.13 Personal liability for a corporation's debts. A member of a close corporation, and sometimes others, can be held personally liable for the debts of the corporation under various circumstances. This personal liability arises when there is a gross abuse of the separate juristic personality of the corporation or when specific legal requirements are not complied with. Members of a close corporation are subject to personal liability in a way that contrasts with shareholders in a company, who are generally not personally liable for the company's debts. This provision ensures compliance with the Close Corporations Act by holding individuals accountable for certain failures or abuses of the corporate structure. 16.13.1 Section 65, Abuse of Separate Juristic Personality of Corporation. Section 65 allows a court to lift the corporate veil and disregard the separate legal existence of a close corporation if there is evidence of gross abuse of its legal personality. This is similar to the provision in Section 29 of the Companies Act, 2008, which permits a court to declare a company not to be a juristic person if there is an unconscionable abuse of the company's legal status. Section 29 of the Companies Act, 2008, if a company is found to have engaged in abuse through its formation or actions, the court may declare the company not to be a juristic person, take further appropriate actions. Comparison, Close Corporations Act vs. Companies Act, 2008. While Section 65 of the Close Corporations Act uses the term gross abuse, suggesting a more extreme standard, Section 29 of the Companies Act, 2008 uses the term unconscionable abuse, which is broader and includes actions not necessarily captured by the Close Corporations Act's definition. Case study, application of Section 65. Airport Cold Storage, Proprietary, Limited v. Ibrahim. The court found that the business was operated in a loose and informal manner, ignoring statutory requirements, such as maintaining accounting records, per Section 56 of the Close Corporations Act. The court determined that the defendants treated the corporation's affairs as their own, disregarding its separate identity. The court held that in these circumstances, the defendants could not use the corporate veil to avoid personal liability for the corporation's debts. The court issued a declaratory order under Section 65, treating the corporation as a personal venture of the defendants, and holding them jointly and severally liable for the corporation's debts. Next. Page 16.13 Personal liability of members in other circumstances. Other provisions in the Close Corporations Act also make members personally liable for the debts of the corporation in certain circumstances. These provisions include: Section 23 requires that the name and registration number of the corporation appear on various official documents. Section 52 prohibits the making of certain loans without member consent. Section 64 imposes personal liability on those who act recklessly or fraudulently. These sections ensure that members are held personally accountable for failure to comply with the requirements of the Act, which aims to ensure legal compliance. Case study, personal liability of members. Hagro Catering BKV van der Merwe. The applicant had supplied meat to a business operated under the name Mr. Meatman, which was actually a close corporation, Toitbert Vleismark CC. The business failed to disclose its corporate status, leading the applicant to believe they were dealing with partners, not members of a corporation. The court held that the failure to display the name of the corporation was a gross abuse under Section 65, allowing the members to be held personally liable for the corporation's debts. Case study, ambit of liability under Section 23. Byway Projects 10 CC v Massanjita Autobody CCTA Massanjita Autobody. This case explored the personal liability of members under Section 23, which requires that certain documents, for example, bills of exchange, checks, issued by the corporation must include the name and registration number. A lease agreement was signed without including the corporation's name or registration number, and the court ruled that Section 23 only applies to specific documents, bills of exchange, promissory notes, checks, and orders. The court found that a lease agreement did not fall under these categories, so members were not personally liable for the corporation's debts. Table 16.4, Personal Liability under the Close Corporations Act. Section Issue Wrongdoing, who is liable. Section 65 Abuse of separate juristic personality. Gross abuse of the corporation's separate legal identity. Court may make any order, including making members personally liable. Section 52 Prohibition of certain loans, making loans without the consent of all members. Any member who authorized or was part of making the loan. Section 63 Joint liability for debts. Failure to contribute. Agreed contributions. Person who fails to contribute. Section 63 Joint liability for debts. Failure to qualify as a member under the Act. Member who fails to qualify. Section 63 Joint liability for debts. Giving financial assistance to acquire members' interest. Members aware of the assistance, or those who received it. Section 63 Joint liability for debts. Failure to appoint an accounting officer for more than 6 months. Members aware of the vacancy. Section 42(3) and 50 Fiduciary duty to the corporation. Breach of fiduciary duty by act or omission. Member who breached fiduciary duty. Section 43 Liability for negligence. Failure to act with required skill. Member who fails to act appropriately. Section 64 Liability for reckless or fraudulent trading. Acting recklessly, with gross negligence, or fraudulently. Any person knowingly a party to such conduct. Case study, factual inquiry into recklessness or gross negligence. Raflatac S.A., Proprietary, Limited v. Bell. The plaintiff alleged that members of a close corporation were personally liable for amounts due to them due to reckless or grossly negligent conduct, including failing to maintain accounting records and permitting the corporation to trade while insolvent. The court found that the plaintiff did not prove recklessness or gross negligence. Despite the corporation's financial issues, the defendants had disclosed their difficulties to the plaintiff, and the plaintiff made a business decision to continue trading. The court dismissed the claim against the defendants personally for the corporation's debts. Next. Page 16.14 Advantages and disadvantages of a close corporation. 16.14.1 The advantages of a close corporation. Less complex legal framework. The Close Corporations Act is simpler compared to the Companies Act, 2008. Convertibility. A close corporation can be converted into a company if needed, offering flexibility as the business grows. Perpetual succession. A close corporation enjoys the benefits of incorporation, meaning contracts are entered into in the corporation's name and remain intact even if members change. Broad capacity. The corporation has the capacity and powers of a natural person, with no restrictions on its business activities, profit, or asset base. The only limitations are the number of members and some solvency and liquidity requirements. Control and ownership. Unless otherwise specified in the association agreement, there is no distinction between ownership and control of the corporation, simplifying governance. Minority protection. Minority members are protected by sections of the Close Corporations Act. Major decisions require majority votes, ensuring that minority members have a say in important decisions. 16.14 To the disadvantages of a close corporation. Complexity due to cross-application of the Companies Act. Although the Close Corporations Act is less complex, certain provisions of the Companies Act, 2008 apply, which can make legal processes cumbersome. For example, the liquidation provisions in Section 66 refer to the Companies Act. Members must often seek legal advice to ensure the association agreement addresses issues not covered by the Close Corporations Act. Personal liability of members. Members may be personally liable for the corporation's debts in several circumstances, reducing the degree of protection offered compared to shareholders in a company. Authority to bind the corporation. Even if a member's authority to bind the corporation is restricted by an association agreement, outsiders may still assume that any member can act on behalf of the corporation for transactions within its scope. Binding association agreement. New members are bound by the association agreement of the corporation, even though they were not party to its creation, which could disadvantage them when acquiring an interest in an existing corporation.